of the invalidity order, so as to avoid the serious prejudice which the millions of poor people could have suffered. Put simply, the Constitutional Court allowed an invalid SASSA contract to operate as if it was valid, because declaring it invalid would severely prejudice the millions of South Africans who are dependent on the SASSA grant. The question thus is why the Constitutional Court failed in the Jordan case to make a similar or corresponding consideration. I think that's the question that we have to ask ourselves. Well, I may not have an answer or even answers to this question. However, one knows that not long ago, it must have been your time, Vice Chancellor, not mine, definitely. We had a phenomenon called the British Commonwealth, and South Africa is or was part of this grouping. It is indeed true that the South African wealth was not common to any or most of the countries forming part of this grouping, let alone British wealth. I remember during my varsity days, whenever there would be these Commonwealth Games, we'll be asking ourselves, what's common about the wealth of South Africa to that of the British? Not common. So we formed part of this so-called common. We also have a particular law or segment of South African law which is referred to as the common law. We know that this law is held in high regard. Legal jurists, scholars, academics, even people on the streets regard this law very jealously. But we have not taken the time to determine or even inquire who exactly is this law common to. Is this law common to many South Africans who follow African traditions, norms, and standards? Is not perhaps the customary law, the foreign customary law, which is applied to determine foreign practices? Lest one gets misconstrued, our endeavor is not to advance a view for the eradication of the common law. We're not arguing for an immediate review of the Constitution. The view is for the development of African customary law and the principles of African customary law according to the African norms and standards which are inherent to this body of law. The view is to disregard the adoption of principles or even laws which are foreign to African customary law as the yardstick to determine or even evaluate the reasonableness or justifiability of African norms, principles, and standards. From the discussions we had in April last year, it was vehemently articulated that the Faculty of Law at the University of Fort Hare is better placed to lead a project on the consolidation of African customary law. To us, this is not a challenge, but an opportunity. However, we do not have all the answers to all the problems. We don't claim to have solutions to all the problems which will result in the consolidation of African customary law. Therefore, for the project to succeed, we will, from time to time, require your support. As we commence with the project and incept the collection of the related data, we will request that you please open your doors and allow us into the communities which you serve and lead. It is through this collective and collaborative effort that a project of this magnitude will be finalized. These 3 days mark a giant step by all of us to chart the way forward. My computer has now died. But I know what I wrote. I know exactly what I wrote. It's me. It's not ChatGPT. So these 3 days mark a giant step by all of us to chart the way forward which will lead us towards the consolidation of African customary law. We will meet again in July next year. We'll meet again in July next year to launch a consultative document which will be, or we will refer to as the consolidated living African customary law. That document will touch on all the related aspects, for example, family law and the law of persons, the law of successions, the law of property, criminal law, the law of delict, and all aspects relating to marriages and divorce. We will invite all of you to be part of that launch. And that launch, as I've indicated earlier, it will be through a process which will be consultative, having regard to the fact that the document has to serve the people that it is sought to advance. I want to thank you, all of you, for taking part in these discussions. We hope that you're going to enjoy the discussions which will be held in these 3 days. Thank you very much.
Thank you, Professor Njotini, for breaking the ice on what brings us today, consolidation and modification of African customary law. Our next speaker is Professor Buhlungu, Mr. Vice Chancellor, and he will touch on the Africanization of the production of knowledge and its contribution to systems of governance in South Africa. VC, over to you. Thank you.
Thank you very much, Professor Pope. Good morning, everyone. Right. Before I start, I wish to acknowledge the diversity of people in the room, and I'm not going to go person by person, obviously, in the interest of time, but I see traditional leaders in the room. I see legal practitioners in the room. I see jurists in the room, retired and still practicing, Judge Madondo, Judge Makaula. I see professors of law. I see academics in other fields as well. We have a friend from Namibia who joined us this morning. There's a participant from Kenya that I encountered as I was greeting people. And of course, I've got a lot of home boys and home girls as well from the other side of the province where I came from originally. Professor Pugo, I just want to say, if you say that by sitting surrounded by royalty, your blood, there's royalty in your blood, I think my claim is a little bit stronger than yours, because I spent 6 years of my youth studying with royalty in a school for the sons of chiefs and headmen. So there's blood in there's royal blood in my veins. Thank you very much. I'm glad that this initiative has come to this level. I think I may miss some of the early steps, but I remember receiving 3 traditional representatives, traditional leaders or representatives in my office. We may have met in East London, and they came and they said, we want to do something. We want to start an initiative. We're not representative, but we've come, I think they may have been sent through the House of Traditional Leaders. But they said, we want to set in motion this big thing about African customary law. And it was me. I said, look, okay, what can I do? I don't teach law, I don't know law, and I don't teach for that matter, but I can do something. And then I started then a discussion. I think the next set of discussions was with Professor Ntlama and Professor Njotini, the dean at the time. I said, listen, I received this delegation of 3, and they did not claim to be representative, but they want to start, if you like, a movement, not movement as in organization, but movement as in kind of a dialogue in society about customary law. And one of the drivers of this initiative, as I understood it at the time, was the erosion of the authority of African traditional leaders, and by extension, the continued irrelevance of African customary law. So that was that. And so that discussion with the 2 professors then culminated in a session in April last year, where we brought together several people. I remember some of the people who are in the room were there last year. Judge Madondo was there. I think he led one of the discussions. And in his presentation, he presented his book on African traditional law, which is one of the kind of authoritative texts, as I understand it, today. But the study of African traditional legal systems goes back, and back, far back. But you could trace among them Professor Koyana, then Digby Koyana, for example, who wrote that book, 1980, was it? Yes. 1980, yes, and many people have come through, with that text as one of the kind of prescribed scholarly works that they had. Now, for me, the deliberations last year yielded an impressive kind of set of ideas, put on the table as an impressive set of ideas. But also I remember vividly that it was agreed that there would be a follow-up session. But I did not expect the session would be as big as this one here. And when I went around the room greeting people, but part of me going around was just to get a sense of where people are from. And we have in the room people from across the country, but it's with a much greater density of representation from the province, from Elusigisigi, Ngeleni, Mtata, you name it, not to mention where we are right now. Now, as Professor Puku said, we have a track record. Whether we claim it or not, we've produced kind of cutting-edge ideas that have transformed society in an era long gone by now. But we've produced those people. And we don't stand on mountaintops, but it's there. The record speaks for itself. But we also believe that we have something to offer in the area of legal systems and society, especially African traditional systems. We think we have something to offer. And we've been training legal practitioners for decades as a university. And some of the legal people that you will encounter in society have gone through the corridors and the lecture theaters of this university. You're not likely to go into any room without encountering someone who studied law, in any courtroom, who studied law at this university. And so we have that proud thing. So I'm very thrilled, therefore, that the Faculty of Law and its partners have taken this initiative to this level, to this where we are right now. I'm very proud, Professor Ntlama, that we now at the forefront of mapping what some call the decolonial path of scholarship and practice in the country, in as far as the legal systems are concerned. It's very, very important. As I've said, there have been many before who have blazed the trail in this regard. I mentioned Professor Koyana, many others, mentioned Professor Judge Madondo, and many others. But I'm not going to make a long speech, except to say welcome to Fort Hare. By the way, just if I may digress for a minute, last year we were declared as a campus as a UNESCO World Heritage Site. In July last year, we are a UNESCO World Heritage Site. So it's up to us, whether we are students, we're academics, we're support services staff at this university, to live up to that reputation. Not every, let me put it this way, not every university is a UNESCO World Heritage Site. If you're from another university, this is not about you, sorry. But I want to reflect on two things. And I was told to say something something about Africanization. Now, Africanization is a complex term. On the face of it, it might seem very easy. Africanization, what does it mean? You put Africans there, that's that. No, that doesn't go far enough. Africanization means infusing African ideas, but what does that mean? And so what I'm saying is Africanization in itself is a very complicated and complex term. And anyone who claims to know what it means is not telling us the full story. It's complex. It's complex. And that's what it means. And also, is Africanization about South Africa? We are very, very interesting society on the continent, especially the Southern African region, because of migrations, because of mining, migrant labor systems, and movements of people up and down. And so whatever legal systems we've inherited are not uniquely South African, or uniquely Namibian, or uniquely Zimbabwean. We tie the bonds that run very deep, that tie us all. Now, so the first thing, therefore, for as long as we have this duality between, on the one hand, common law, on the other hand, customary law, then Africanization is not going to go anywhere. It's not going to go anywhere. What it means is that we remain, as we stand here, with this bifurcation of the legal systems in our country. And you can see it. You see it every day. Okay, if I have a case against Professor Njotini, I'll take him to the traditional court, and we'll deal with him there. But if I have an issue with another person, I'll go to the common law courts in town. And if I'm not happy with the traditional system and the outcome of that lawsuit, I'll then go over and go to town too. And so what you have a situation that prevails where customary law remains the other, where customary law becomes the poor cousin that sits on the margin. And that is the issue that we must confront. And it's something that we have not even started to crack. And I know now we've set in motion a whole lot of things. We have houses of traditional leaders, Nkosi Mavuso, the chair, and welcome. We have those houses. Do they make laws that are binding to everyone? Do they make laws that are binding only to Africans? Do they make laws that are binding only to people in rural communities? Can they be binding on me, sitting here in Alice, for example? Those are some of the questions. So you have this bifurcation, and people can make a choice. And it can be out of convenience that people make a choice. If they think my chances of success are with the customary traditional courts, I'll go there. I'll go to the traditional community there. But if I'm not happy with it, then I'll simply say, okay, fine, thank you very much. And I'll walk to the next, and the next, I'll go to the SCA, and then I'll go to the Constitutional Court. And so there's that tension. And that tension is part of the menu of issues to be addressed by this process, not just today, but into the future. How do you get away? This bifurcation is a subject that Professor Mahmoud Mamdani spoke about many years ago. I think his book came out more than 20 years ago, about the bifurcation of society, where you had these two systems kind of coexisting, but one two notches above the other. And that's the reality that we have. And even as we train students, because we train students in the university, we need to grapple with that. We can't train students as if that bifurcation is not there. And I'll speak a little bit about curriculum in a minute. So, just to extend this point, therefore, about the traditional systems, traditional courts will remain irrelevant, and their decisions will always be overturned by the common law courts, for as long as this separation exists. For as long as this, and so when the 3 delegates came to meet with me, and they were very deeply, deeply concerned that the system the country, the democracy, the new dispensation is oblivious to the erosion of the power of traditional authorities. They said, we don't control land anymore. And in fact, I may extend from my own observation, having lived in this area for 9 years now. I've seen this area where, for example, the control, the grip of traditional leaders over land, the allocation of land, has slipped. Various syndicates sell plots of land now. And you see grazing land, you see old farmland has been taken over. People build houses. The traditional leader wakes up in the morning. There's new houses there. They have no control. They don't know who lives there. And so those are some of the things, therefore, that will be. And so if traditional courts will become irrelevant in this scenario unless something is done, traditional leaders also will remain bid players. They'll become irrelevant. If you look at the juxtaposition in Bisho, you go to Bisho, you see the legislature on the one side, there, visible, kind of clear. And then in a corner somewhere, you see the house of traditional leaders. In the bush, almost, hidden away from view. And that is a metaphor for what we're dealing with here. That's a metaphor for what we're dealing with. Let's face it, the traditional leader now has less say. And I won't dwell on that one. But then, I should then come to another point, that the legal fraternity, especially researchers, practitioners, jurists, and others, they cannot walk the path of Africanization alone. I think that's very, very important. Most of us here, people who are either traditional leaders, practitioners, but all in the kind of space of the law, whether customary or traditional. And my argument this morning is that you cannot walk this path alone. You're not going to win. You're not going to win. The task of Africanization has got to be bigger. It's got to be in bigger hands. It's got to be more inclusive. Because the issue of Africanization is not just for those who practice the law, who adjudicate the law. It's for everyone. And this is how you need to join forces with other fields of scholarly endeavor in transdisciplinary engagements. Now, I want to illustrate this by just making references to 4 seminal classic pieces of scholarly writing that are not law. But for us growing up, Prof. Jordan, you said in my time, in our time, how we encountered the law and the complexity. The first one is a classic by S.E.K. Mkai, his novel, Ikyala la Mawele. Now, here's my argument. I'm going to make a tongue-in-cheek kind of comment on this one. Please take it as such, tongue-in-cheek. If you teach law and you don't prescribe Ikyala la Mawele to your students, you're doing them a huge disservice. A huge disservice. And if you teach law and you think you're going to Africanize anything in the curriculum without prescribing that text, you're doing your students and yourself a huge disservice. Because Ikyala la Mawele grapples with precisely this bifurcation. It grapples with this issue. And it shows you how the system, the issue of a lawsuit between these two twins, and that's how African society operated then in 1914 when Mkai published the novel. And that's how it operates today. And so that's how you have to grapple with issues of Africanization. The second text, published in 1925, was by Thomas Mufolo, originally from what we call Lesotho today. And he wrote a book, rather a novel, called Shaka, about King Shaka. He interviewed people. He even went to KwaZulu-Natal. He went to the grave of King Shaka, and he studied the complexity, the issues that people were grappling with. about the issues of traditional leadership, about the issues of society, about the issues of the authority of traditional authorities and the role that society played in all of that. Again, it's another classic, and that is very, very important. A third one, published in 1930 by Saul Plaatje, is another novel, a third one, called Mhudi. Now, Mhudi, again, was written in a context of conflict, of war, of dispersion, of migrations of people, of conflict in families, conflict in communities, and conflict between Africans and the Afrikaners. Okay? Again, it speaks to these issues about land, who has authority to allocate land, who can come and take land away from others. And then the final one I want to refer to, of course, another classic that speaks to these issues. And again, I will say, if you don't prescribe this to your students, you're doing them a disservice. I'm saying this tongue in cheek. Published in 1940 by A.C. Jordan, Ingqumbo Yeminyanya. He translated it to the wrath of their ancestors. Once again, it speaks to these issues about law, about what is law, and what happens when these two collide. And so I'm saying, therefore, if you think as lawyers, or law practitioners, law researchers, you're going to deal with issues of Africanization by yourselves, you're not going to go far. Go to literature, go to anthropology, go to the various other disciplines. Go to other disciplines and find out and work together, because some of the answers or some of the elements of the answers lie in those disciplines. But they're not going to do it by themselves either. The answer today is transdisciplinary work. Seek out knowledge from other places, from other areas of scholarly endeavor. And that's the name of the game now. And I know lawyers, they run our lives, right? They run our lives. They tell us what our rights are, and they tell us when our lives are about to hit a dead end. But this time, I think lawyers can benefit by listening in the same way that other areas of scholarly endeavor, Prof. Osode, can also benefit by talking together. What is this Africanization? How does it mean? What does it mean when we have to learn from others? So, in other words, Africanization means going back to society. Go to the very African society that you claim to be working with or working to benefit. Which brings me to my last point, and the issue of curriculum. Fortunately and unfortunately, I have no idea what the law curriculum in universities has been over any time. From the time I was a student, I never did law. I never wanted to do law for reasons that are not relevant here. So I don't know how it was and how it has moved and shifted and transformed over time. But I suspect that customary law has always, common law has been the default in all the time. Even today in our thinking, when we think about things and we think about rights, we just say the Constitutional Court. Once the Constitutional Court has decided, that's it. We default on it, almost blindly, almost as if nothing else. And the Africanization just evaporates from it all. It's interesting that Professor Njodini made a reference to this question about surnames, because I've been listening to this to the rumbles about this question of surnames, that men can now take their women's surnames and so on and so forth. Once again, that's where society is at. That's where society is at. And we need to listen, take heed of what's happening on the ground. And that you can find it in various other areas of scholarship where they've been dealing with it all the time, all the way down. You'll find it in the works of some of the most celebrated scholars in the various fields, whether it's in law, whether it's in philosophy, and so on and so forth. So I'm saying that's that. But the curriculum itself, Prof. Njotini, I think there could be various endpoints and outcomes, maybe 25 years after our time, maybe 25 years after our time. One would be the Africanization of the legal systems, where there's a real, we're not just talking about modifying African customary law to fit in with the common law, where there's a meeting point somewhere. So that should be the one part, the one outcome that we should get to. But the second outcome is a new curriculum of the future, a new curriculum that is truly African, a new curriculum that's truly African, that does not seem to do favors to African customary law, which is not to say, okay, we understand here, which is not to dish out little favors, but which is genuinely about it. Again, I want to underline my final point. It can't be a South African undertaking. At the end of this day, we are now at this step. I think the next stage should be to find out from other African and beyond African communities, areas of scholarly endeavor, legal kind of practices, and see where we can learn from it. Whether it's from kind of the Middle Eastern communities, for example, how do they grapple with these issues? The rest of the continent, how do they deal with these issues? In the end, we're not an island. And so with those comments, I'm very excited. I wish I could stay here and listen to some of this. And also, I hope I've provoked a few people, especially if you think that your curriculum is fine and that no one has a right to tell you what to do. I hope you've been provoked sufficiently to begin to think a little bit more about the future. Thank you very much, and welcome to Fort Hare, and enjoy the discussions for the rest of the colloquium. Thanks a lot.
Thank you very much, VC. I think there are three things that one can take from your presentation. But on a lighter note, I want to share why VC is not using a laptop. I overheard him somewhere. He usually visits my office and other offices. So he said at one stage he was presenting and the laptop decided to go off. Thereafter, he told himself that, you know what, the best thing you could ever do is to always print your speech, because Prof. Njotini, the speech will never run out of a battery. Thank you very much, VC. Consolidation, Modification, Africanization of Customary Law. You touched on, the dynamics surrounding the applicability of customary law within the South African context. But what is interesting is that Section 211 of the Constitution, provides that you can only apply customary law if it is in conformity with the Constitution. Therefore, you wonder if you consolidating it and modifying it, will it be a separate legal system, or it will be subordinate to the Constitution? I don't have the answers, but what I can assure you that the next panel is going to grapple with these issues and hopefully provide answers. But before I do that, I'm going to give everyone 3 minutes short break so that when we come back, we can hear what the panel has to offer. So we are breaking and we shall be back at about 12 minutes to 11. Thank you. It's a short break. Sorry, a short announcement. The driver of vehicle 15 RMZN, if you could please move it, it's obstructing the flow. Thank you. 15 RMZN. Thank you.
sebebhayindile apha uyabona. Testing, 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 testing.
your seat, you will choose wherever you will feel comfortable. Each speaker will have 10 minutes to present. There will be a timekeeper. He or she will show you when we are left with 5 minutes. And then when he shows 1 minute, it means your time is up, you need to wrap up. Ladies and gentlemen, allow me to call upon Professor Ntlama Makanya from here at Fort Hare. Her topic is the interrelationship between medicine and law in a constitutionalized system of customary law. A round of applause for her. Welcome, Prof, on stage. Our second panelist is Nkosi El Mavuso, who is the Deputy Chairperson of National House of Traditional Healers. His topic is uniqueness and influence of the institution of traditional leadership in the regulation of state authority in South Africa. A round of applause for Nkosi Mavuso. Oh, pardon me, it's leaders. It's more closer to one of the research topics I'm working on. Thank you. The fourth speaker is Queen Nokwanda Dalindyebo, Abatembu Traditional Kingdom. Her topic is experiences in exercising authority and regulating customary law practices in the institution of traditional leadership, making progress or regressing. Welcome on stage, Queen. I saw her, she was here. May I also call upon Ms. Lisette van der Merwe from the Department of Cooperative and Traditional Affairs. Her topic is integrating the legalized customary law into an administrative system of governance. We are missing one panelist. Our ushers, please try to locate her, but she will join us in motion. Professor Makanya, over to you. You are free to either speak while you are seated or the podium is also available for use. Over to you, Prof.
Thank you, Program Director. Let me just and say the protocol is observed. Good morning, colleagues. Professor Puku didn't tell that I am the Dabao of the faculty, but now I was promoted to a Dabao of the university. A Dabao is an aunt. Right, colleagues, I have not prepared a speech or an academic speech on purpose or an academic paper. The reason being, I want to speak from the heart. And my speaking from the heart is motivated by the integration of medicine and law. And in a customary law context, we have two particular legislations that regulates that practice of initiation. That 2021 legislation, that 2016 legislation, they speak to the way in which that practice has to be exercised. And the motivation of bringing the topic of medicine within the context of customary law is the fact that applications of those laws are interpreted independently or outside the framework of medicine. If medicine, the modern medicine, carries those particular principles of doing no harm, doing good, doing justice, independence, why would those principles not be used and be framed within the framework of medicine when we exercise this particular practice? I'm not here, colleagues, to speak about the negligence or about those illegal schools, but I'm here to speak about the genuine initiation schools that monitors, that assess the initiates. If the modern doctors, I would say they are negligent, they are not criminally charged. But if our traditional doctors or nurses, they commit whatever offense, they go through the criminal route. But the modern doctors, they go through the civil route, that they were negligent. So the integration of medicine and law, as we strive towards consolidation, we should be interpreting we should be integrating the application of those customary law or prescripts that are envisaged in those particular legislation through the framework of medicine. Because medicine, when we apply it in that context, it enables us to ensure the evolution of the principles of medicine in the context of customary law. So why would the performance, why would we not expect our traditional surgeons or our traditional nurses not to be at that level, that we expect of them to ensure that their professional undertaking, because what we expect from them is to ensure the quality of preserving that custom so that we eliminate all this negativity around the practice. Because there are calls now, abolish this practice, the boys are dying and so forth. But both the Dean and the Vice Chancellor are here. If we are not pulling the bull by the horns and ensure that the prescripts of medicine has to be infused within the way in which we practice that custom, because we have to view it through the lens of medicine. And when we speak of those access to health care, of those quality right of dignity, they encapsulate those values that are embedded in a customary law context. So if the initiates are under the care of traditional surgeons, they have also to perform beyond expectation, as is the case with modern doctors. And we are not here, colleagues, for sameness. We're not here for sameness. But the principle that we have to uphold is to how do we develop our own system within the context of our own, so that our own system is able to influence and be influenced by the general framework of the law. The Constitutional Court has said so many times, going back to Alaska, that indigenous law has come not to be interpreted through the lens of common law. But how do we do that in practice? We are very happy to see. We are very happy to interpret. Now, customary law has been given a constitutional status, but to what extent that constitutional status transmits to the lived realities of people? I'm not going to say much. I'm done because I've said I'm going to speak from the heart. My heart has spoken that interpret medicine through the framework of the customary law prescripts that expects as well our surgeons to ensure that they uphold those values and principles that classifies our well-being as people that subscribe to the system of customary law. Aye man, wazantsikelelo siphila ngengxaki. Waza wena wethi koMazulu. Waza yo sikhona ngoku. How? Imagine. Thank you very much, colleagues.
Thank you, Dabawo, speaking directly from the heart. Colleagues, just a slight amendment on the program. We will now have Chieftaincy Nobongo Ngonyama to represent Abatembu Traditional Kingdom, and she will speak on commentary on the administrative role of traditional authority. If she may please proceed to join other panelists. Nkosi Mavuso, over to you, sir.
Let me observe the protocol. Let me stand on the protocol that has been observed. My take this morning, Prof, after the two presenters, the Dean and the VC, was that we are starting a revolution. We will be opposed because there is something that we have identified in the country, the new colonialism. Marginalize traditions and culture through policy, so that even if it's taken to court, it cannot stand. I want to challenge the university. I'm a student of Professor Osode. I think I must make that disclaimer. We are busy in the country with the Department of Justice doing regulations on Traditional Courts Act. In the country, we are 893 traditional leaders. KZN 320, Eastern Cape 232, Free State 13, Limpopo 178, Northwest 45, Mpumalanga 45, and Northern Cape 8. We are expected in terms of the law to preside over these traditional courts. As you roll out this program, Tin, we must be able to capacitate traditional leaders to preside over these courts so that even their judgments stand. So, and we need to promote our justice system because our justice system is restorative than punitive. I would say we can't expect the role of the legislature to be done by the judiciary, because The judiciary that we have in this country has not been trained on African customary law. And therefore you can't expect them to interpret it. Rather, they've been trained on common law. So the failure of the legislature not to promote customary law is something that we should take it up with them. Our constitution is under extreme attack. People are saying we have the best constitution in the world. I disagree. Our constitution is very Eurocentric. My daughter is doing LLB third year in UCT. She's asking me, Tata, how did you come to this liberal constitution? Underneath it is economic apartheid. How did you come to this constitution yet still oppressing us as black people economically? So in other words, Prof, the university has to work with us this journey. We capacitate traditional leaders. I'm very pleased to know that there's a big delegation of women traditional leaders in this colloquium. Enkosi bomama. For instance, there are pieces of legislation that at some point they seek to harmonize the relation, like the Customary Initiation Act Professor Nhlama talked about earlier. It seeks to regulate the issues around the children's right and the right to health and so on and so on. So in other words, we have a mammoth task ahead of us. There's a need to address the shortcomings in all these pieces of legislation to ensure that it accurately represents customary law. For an example, at some point in time, international funding had a problem to fund customary initiation, but they wanted to fund medical male circumcision. That all of us must go and queue at Victoria Hospital to get circumcised, which is not in line with our custom. So in other words, customary law is a living law evolving with the needs and practices of these communities. It serves. Therefore, the judiciary has a role to play in this process, applying living customary law and ensuring its alignment to the constitutional values that we have to challenge as this movement. Thank you, Prof.
Thank you, Nkosi Mavuso, on an interesting topic, touching, very societal issues. We don't know the answers, but I assume the Q&A session will answer whatever the issues that you might have raised. The next speaker is Nkosi M. Dumalisile. Over to you, ma'am. Oh, sorry.
No, let them talk. He said the master just read his presentation, but let them talk.
Okay, it's fine. You may proceed. You are welcome to be seated, or you understand either way.
Good morning, and all protocol observed. My name is Lizette van der Merwe, and I'm from the Department of Traditional Affairs. I am actually tasked, and when I read the program, Did I mention all protocol observed? And everybody looks beautiful today in their traditional way. I was tasked when I look at a program and when I look at a team actually, there was a question posted to me. Constitutional customary law, is it a myth or a reality? As a lifelong learner and scholar, and after digging in and doing my homework, I can firmly say that constitutional customary law is a reality, not a myth, but it depends heavily on the legal system and constitutional structure of a country. The constitutional customary law refers, in a nutshell, to the legal norms and principles that are not written in a formal constitution or statute, but has developed it over a period of time through long-standing practices, traditions, and accepted conventions, and are recognized as binding in an operation of a country's constitutional framework. My topic is integrating the legalized customary into an administrative system. Simply put, and in a nutshell, integrating legalized customary law into an administrative system of governance means formally recognizing and incorporating traditional customary law of which originate from customs, values, and practices of local communities into an official state-run and legalized framework. This would then mean, if we look at a country like South Africa, the Constitution of South Africa does recognize customary law, but it must align to the Bill of Rights. If you compare South Africa to Ghana, chiefs are constitutionally recognized and play a role in land and customary law matters. However, in New Guinea, customary law forms part of the national legalized system, especially in local levels. So in summary and in closing, my integrated legalized customary law into governance means allowing traditional rules and institutions to function within the official state system, ensuring that they are recognized, regulated, and harmonized with constitutional values, especially, which is very important, human rights and the rule of law. I thank you.
Greetings to the amakhosi alapha. Ndicela uqala ngabo abanikazi belizwe. Namaphakathi wonke aphakathi kwenkosi. I think you'll understand what I'm saying when I put it in that way. And I would also like to write on the protocol that has already been established. My name is Nkosikazi Nobongo Ngonyama. I'm the Regent Chieftainess of the Tsatsato Traditional Authority. I'm intentional when I say authority. You go and check the constitution. There's no council. And what I want to emphasize and highlight is that amagama esiNgesi nawesiXhosa akahamba gqwethane. In Xhosa, when we talk of uncle, it's completely different from us and our interpretation. There's a malume, there's tatomncinci, but in English we encompass all that into uncle. So I'm intentional when I say authority, because the authority ligunya, the council liqumrhu. So we'll elaborate when we get into further discussions around this matter. But before I continue, I've been mandated by the Honorable Queen of Abathembu Dalingebo, uNkosikazi uNokwanda, to stand in for her. And she profusely apologized that she couldn't be here due to emergency that they experienced. But she said to me, Mam Nobongo Ncede, kindly acknowledge amakhosikazi that are from Dalingebo Kingdom. I would like to mention them, and if they are not going to be offended, just to say and raise their hands. We do have, these are regent chieftainesses. Abazanga nje apha babekhaphile baphethe izizwe. It's Nkosikazi uNobulali she's Nkoskazi uno Italy, she's Nkoskazi uno Kaka, sinaye ke nonkosi sinayo notata phakathi kwethu unkosi uMinenkulu Joyi, who happens also to be the representative of the king at the Provincial House of Traditional Leaders. So we are from a strong kingdom. So I just want to convey that as she has put it to me. Ndingathi ndinikwe umyalelo ndingawenzi. The question that we need to answer, I did prepare after I got the call or after I spoke to her, but my preparation might not be as the preparation that she had prepared. Kodwa ke, I will be talking also from the heart because of the experiences that we come across in this institution. It talks about the question that we need to answer is to ask ourselves whether the traditional leadership is making a progress or regressing. I can safely say, and I'm without a doubt on that one, we are making a progress. But the progress that we are making it we are so suffocated because of the circumstances, because of the systems that are put in place. When I talk of systems, and intentionally again, because each and every government has got its own systems. We used to talk of apartheid system. Now, this one, I've termed it, that's my term. You might buy it or you might not. I say it is a government that has created a dependency syndrome. You'll talk of a grant, you'll talk of abantwana abamithayo no bamithe bayi-10 urhulumente uzakwenzela uzawakhela indlu. So it's a dependency syndrome. There's a reason why they are doing that, because kaloku kufuneka uyazi uba xa bethi sivotele ngoku uzawuvota. Kodwa ke ngoku we want to liberate ourselves from that. Without talking out of the topic, but the system that now has been created is the system that wants to suffocate the traditional leadership institution. Why I'm saying so? It's because if we go to rural areas, this issue, it's new that we have got councillors during this current system. It used to be traditional leaders that were looking into the issues of community development, that were looking into the issues of ensuring that the stability, that were looking at the issues of making sure that as the people of each and every community, we live in peace and harmony. But currently, all those things are things of the past. We lock ourselves in our own yards because of the fear of what is happening, because of the system that has been introduced. Uzawutufuna ileta, unto waselalini, ithi banki, we are not going to accept a letter that comes from a traditional leader, rather bring it from the council as a proof that you are the resident of a certain village. I'm talking about the system. But despite all those challenges, we rise and we try at our level best to rise above them. And what I appreciate now is that at each and every platform that I've come across, people have soon realized that we seem to have abandoned a system that was working so well for us. And now wherever they are given an opportunity to open their mouths, but ziphi inkosi zethu. Sifuna inkosi zethu. Hence I'm saying the traditional leadership institution, it's not regressing, it's rather progressing. And the people that seem to have looked away from it are now starting to take their eyes back to the institution because of looking at the challenges that we are experiencing now. One other aspect that I want to highlight of acknowledging this institution progressing instead of going back is the fact that as much as we had in the past women traditional leaders, but at this day and age, even the court cases that are decided are entrenching women leaders to say, Nikona, and we acknowledge you. We can mention the likes of abantu who fought tirelessly, despite the fact that abafazi at the time were not though they were recognized and they were considered to be leaders, but that issue was a bit pressed down on them to say, "Uyiyo, but you cannot say some other things." But the likes of Queen Nonesi, the likes of the Queen Onoachisi of Abatembu. But at this day and age, you can safely say we do have princesses. As much as one would think of what is going to happen now when we talk of a succession, when we elevate a princess, because we are into bana ayizudumithiswe kweli khaya. It's an issue that we know, and we acknowledge the fact that it's a river that we are going to cross when we get to it. So in order not to cloud the issues, ensure into okokubana whoever is supposed to be leading at that particular time can never be rejected because you are looking at the future. Not that we want to be ignorant of that, but we know how to do it and when to do what is supposed to be right. Xa ndizawuvala, ndiyafuna ke noyivelela into ethi ndiyambulela umama uNtlamo uye wathetha ilanguage yakhe ndiqoma ndi-excited because sikhumshe isilungu siphele esithubeni. Uqonda into yobana ndifuna uyibeka ngale ntetho yam ukwenzela uba izovakala. Ndiyanqwenela ke ukuchaza into okubana as sijonga nale topic nale colloquium that is so etyebileyo teketeke kangaka ezothetha ngobuntu bethu. It is important to know that for us to be able and to appreciate and embrace this custom, we must all know into okokubana seated here, custom is our identity. We are who we are because of our customs. We are who we are because of our cultures. And that can only be embedded in customary law. Siyaba respecta ke otatma Ndondo in our presence, we are respecta otatma Kaula, bona ifocus yabo as much as they will embrace the customary law. But we know in Togobana, when they do whatever they do in their space, they will always consider the Roman Dutch law. The Roman Dutch law, truth being told, iyahlabana ne customary law. Let us be comfortable to talk about those uncomfortable issues. Xa ndizawugqiba ke ndizawuhlala phansi ndirhala into okubana as we'll be going and digging deeper and talking about these issues, let us know one thing. When we talk of exercising our authority and regulating customary law, go and visit the case laws that were decided in the past. I brought them here because I knew at some point when we get to these commissions, if there will be commissions, I will have to talk about them. What I appreciated in the past when I looked at them, I read them going back as far as 1800s. They never, those commissioners, all of them were whites. You'll see their names written there, white people. But what they embraced and they respected was that they never decide on a case without calling the people who have got a knowledge in respect of each and every culture. They would sit with them as assessors and they will solicit their opinions, and when they decide, you will clearly see in their written judgments that so-and-so said this, so-and-so said this, but then they differed on that one. Then this one had to explain that this is a Galega custom, this is a Tembu custom. That's why they differ, because we practice different cultures. So in a nutshell, when we talk of exercising our authority, regulating the custom, and ensuring that it progresses, I can safely say that we are an institution that will never get distinguished, or that will cease to exist for as long as we live on this earth. So, pambiling a customary law, thank you so much.
Thank you so much, Chieftaincy Nongonyama. Prof. Osode, I'm willing to forfeit my tea break because I'm full from these enriched presentations. Such provoking thoughts. You know, I wonder whether the two systems should coexist, customary law and the conventional system, or are we trying to integrate the other to the other? So I don't know, but this slot now is for us to interact and engage our audience. We are welcome to ask any questions. As you ask your question, please be specific to whom you are directing it to. Please keep your question, just shoot straight. Don't go via the gate first. Straight to the question. We are a little bit behind with time, so I will start with this row. Either at the back, middle, or front. I think they are still, formulating the question. Judge Madondo, can we assist with roaming mics?
Thank you. My question is directed to Professor Ntlama Makanya. When she is lamenting the fact that the medical practitioners and our traditional healers are not treated the same. But the problem, in my view, lies in the training, qualification, and so on. So how the traditional healers' qualifications are going to be assessed, or their knowledge in what they are doing.
Thank you, Judge. We are going to take 3 questions, then panelists can start responding. Yes, sir, there's a mic next to you.
From the Kalahari, I came to this place and to this institution. I think that I have to agree with what MC was saying, the birthplace of the African people's agenda. We had a problem there, which was suddenly looked at it by then President Mbeki, former President Mbeki. Before that, it was the Tata Madiba, who provided a platform for us now to engage meaningfully, that with regard not to the land, not to the land. So that what he did was he then interacted well with us. At that stage, it was that Upadawad Kraper, a family of mine, Kraper family. Today we have the municipality named after him because of the steps taken by Tata Madiba and President Mbeki. That we were told that we were not human, that we were told that we are unbelievers, that we were told that, for example, myself, I was denied at institutions of higher learning at UCT, and of course, Stellenbosch. The only institution that took me in was UWC. For that I'm very fortunate. It's because of them that I'm standing here today, for the education that I've received from that institution. Because I was told by the other 2 institutions, you would not be able to do it here. This is not for you, because look at how you look like anyway. Like I look now. We had huge problems, but at last, that we were able not to get the land. And the question then that what I'm asking here is, well, that our panel also now to make sure that the Khoisan also being included in all the discussions and deliberations that which we have, not only here, but also that through the country.
In conclusion, sir?
And in conclusion, well, there of course, We have that what we call the IKS, Indigenous Knowledge Common Systems, which has now become a very buzzing word, not only in South Africa, but all over the world. To be able now to look at it, and also to make sure that it's being distributed more and more within society. Thank you.
That question is for everyone because, you know, it had a historical background. Thank you. Last one.
Thank you very much. Protocol observed. I'm Mandela Makaula from Mount Frey. I wear two hats, Eobukosi plus Neobuchachi Ndizenge Eobukosi ke apha. My question is linked to what JP has said about ukwaluka. As Prof. Ntlama as well as Nkosi Mavuso spoke. It's male-dominated. It's a custom which is run by men. I'm a beneficiary of the same custom, but the major problem is children are dying. Scores of children are dying each year because of lack of supervision from whoever is supposed to supervise the children. As Unkosi Nzambiza Undumi uzongixolela kwanamhlanje. Undumi has said, that's affectionately, I affectionately call her Undumi. The problem now is that we have many female traditional leaders. What role are they going to play in supervising the custom if the custom itself is male-dominated?
There you are. Who is ready to take the last one? Ma'am, you are looking at me. I think you are ready to take it. Okay, Nkosi will take it. Dabao, the first question was directed to you in that order.
Thank you very much, colleagues, and also thank you to Justice Madondo for poking the snake out of its own holes. The reason why I'm saying that there has to be the way in which we view the practice of initiation through medicine is the fact that traditional surgeons, traditional nurses are equally trained to perform the operation, if I put it that way. Because that is the operation. And that operation, they perform it in their own context, as is the case with those medical doctors when they go to those theater, to those operating rooms. So when we go to the bush, when we go to the bush, that is the operating room where you are going to perform this operation, so that operation goes well. So if you don't exercise due care, if you are negligent in respect of the way in which you conduct that operation, will come back to you. And on the other hand, Judge Makaula, when it comes to the issue of the male dominance now in the performance of the practice, I would boldly say, please, women, stay away. That custom is not for you. Women, stay away, because that is a justified discrimination, because it is linked to a legitimate purpose wherein men, they have to exercise that operation. I will go further. Oh, let me leave it. And say, hey, women as well, I would say, women as well must stay away from the throne. They don't belong there. They can hold any other position. They can hold any other position, but not the throne.
Thanks, Prof. I think Zulu, let me comment around the issue of initiation. We're in an era of lawlessness and spoiling people. You know, I still respect Amatlubi and Abesutu when they perform initiation. When it's that season, every man goes to Endabeni. And in those areas like Stekspruit, there's a person called Inkosi Yendaba, who reports to a traditional leader of that area. So those people, they do initiation communally. Unlike us, that I take my son, you take yours, you take the other one, and so on and so on. So, and after that, parents, they delegate their responsibility to traditional leaders and government. For instance, our children, they take chronic medication. So when he has to go to the initiation school, his parents should alert the surgeon that this child is undergoing this medication, so he has to do this. And what is killing children is gangrene and dehydration. Because they've got a perception that if you don't take water, you heal quickly. And you ask a question, where is the father of this boy if the child will not take water? Because it's not Mavuso who is taking children to the initiation school. It's Prof. Osode's family issue. It's not a communal issue. Perhaps we need to go back to do things communally. Thanks.
I think let us agree, we can agree to disagree that kuphele what I would call amakaya, kushiyeke izindlu ezinabantu. That is very important. I'm saying this because the question that is being raised around the children that are dying, we lament as women very strongly and very sharply about that aspect, especially us. I want to talk about single women, be it you are widowed, be it you did not marry. The reason is it's because if me having children, I don't intend getting married again. My husband passed on, and I want to believe that those children are going to carry the name of my family forward. Now, if they get to this practice and either they come out in a coffin, or the part that is supposed to take our family name forward is not there. It was not meant for cosmetic purposes. It's serving a purpose of carrying the name. If now it gets to be amputated, then the name of my family is dead. That's why we are very sharp and we are crying aloud about this aspect. Be it us crying aloud, we are very cognizant of the fact that there are lines that we don't have to cross. That is very important. That is the beauty now of embracing a culture and a custom. If we get to cross those lines, it would mean we are revolting against our own customs and against our own cultures. That can never be started by us. All what we want is to say, protect our children as men, but we are also at the end with our roles that we play as women during this season. Cooking of the food of the children, it's us who does that. Building the house or the initiation, it's us who goes out as women to cut that grass. So there are roles, but we know what role to play and where to stop playing the role. Thank you.
Thank you, ma'am. Ms. van der Merwe, you're fine. Ladies and gentlemen, someone whispered to me that tea is getting cold. And these discussions, we can still take them over to tea time. But before we do that, let me thank our panelists, for robust exchange of ideas. So were the audience. I wish that this discussion can go even beyond lunch, but we have different themes. can we please give our audience, including the panelists, a round of applause? After tea, we are all coming back here. Since we are behind time, tea will be 30 minutes. But one more last thing. I also thank myself for having presided over this session. Thank you.
Thank you, Prof. No, it's fine, people. Sorry, colleagues. Sorry.
Tis our band, Pelelev, hi.
Good day, everyone. I would like to call the speakers for this day under the theme, Policy Interventions in Customary Interpretation. My name is Dr. Nombulelo Lubisi Vizani from the Faculty of Law. Our first panel member is Justice, fourth speaker from University of Cape Town. The topic, feminism and the right to gender equality in polygamous relationships. The fifth one is Mr. Mfundo Maqanda from the Eastern Cape Department of Cooperative Governance and Traditional Affairs Department. Topic, administering communal land for commercial advancement through the lens of customary law. Over to you, colleagues. Mr. Mfundo Maqanda and Dr. Zamambo Mkhize. Now, before we start, there was a question that was asked here later in our last session from one of our traditional leaders. I will request Professor Ntlama to come and respond to that question. Over to you first, Prof.
Thank you very much, colleagues, for the indulgence. As Doc has just said, we did not respond to the question from our chief. He expressed, I would say, his head, if I put it that way, because of non-recognition. I could tell when he expressed himself on how the system has excluded them. My response, as much as even when the Traditional Leadership and Cohesion Act was adopted, myself, I even asked, what is this? Because we have the traditional leadership system. Now we are being pigeonholed. As much as we might not have the general or the national system of customary law, but I don't have an answer for now for him and also for this house, but to just say the time has come now in terms of us moving forward to reorientate on how we deal with their history and the impact that they have today in consolidating our moving forward, in consolidating our transforming the traditional system of governance. So this is an opportunity that is presented to the community. Not to see them as a by the way. We have been talking this lot of much about, no, we are no longer a poor cousin, we are no longer this and that, but the time has come, as I'm saying, let each group be recognized in its own context so that they are able to influence and be influenced within the framework of their own living. So that is the general purpose of us being here. Because that transformation or transforming of the mind, it enables each one of us to have space now. Not to be inboxed, but you are able to perform. You must be able to influence. You must be able to be influenced. Let me leave it there so that I don't take too much time. But we are giving space for everyone to say, this is what I can contribute, this is what it means for us, and so forth. Otherwise, thank you, Doc. Thank you, the panelists as well for taking your time. Thank you, colleagues, as well for giving this opportunity. Thank you.
Thanks. Let's give Prof a round of applause again. Okay, thank you so much, Prof. Let me not waste time. Let me give the panel members time to say words under this theme. I think I will start with you, Judge. Can I? Under the theme, the courts and judicial interpretation of the customary law principles in South Africa. Thank you so much. You can stand.
For the point of correction, Program Director, I'm Jabliseni, not Mbuyiseli. Jabliseni. Mbuyiseli is Madlanga. Yes. Well, you didn't tell me how much time do I have? Or I can talk till the crack, until the crack of doom. Okay. Well, you said 10. Okay, if it will be less, then I will complain. Other people are 10. All right. My topic here, you say court judicial. My understanding, when you talk about court, you say judicial interpretation. You can't mix the two now. It's one and the same thing. So I've cut it shorter than judicial interpretation and application of customary law principles. I will start with the definition, even though I know that you know what it means. Definition of a customary legal system is the legal system that developed from the way of life and natural wants of the people, the customs and traditions or practices or usages traditionally observed among the indigenous people of South Africa, which form culture of these people. If a thing forms a culture, it means the thing you are living by or living with. There'll be no time when we are not doing that. The colonial rulers, as well as apartheid oppressors, regarded customary law as being backward, rooted in the past, and inherently superstitious, and as a consequence, it had to be removed or radically reformed or developed by importing Western laws, namely English and Roman Dutch laws, both combined, later became known as the common law operating throughout the country. That's the common law people have been referring to. In Alexander, in the case of Alexander, the Davis Rachterveld community, the Constitutional Court said, indigenous law is not fixed body of formally classified and easily ascertainable rules. By its very nature, it evolves as the people who live by its norms change their patterns of life. It has throughout the history evolved to meet the changing needs of the community. So I will deal with three aspects under this topic. The first one below is somehow mixed. Development of customary law. How people should go about in developing customary law, not as they wish. The official customary law is out of touch with the social dynamism and practical or grim realities of lives of the members of the traditional communities and adherents of the customary law. So if it is out, is not in touch. So those laws, old laws which were enacted by this colonial and apartheid regime, so if you refer to those laws, they are no longer applicable, even if they have not been repealed. But in terms of how the people are living today, they don't find a space anywhere. So the customary law should be permitted to develop in accordance with the practice, norms, and values of the community concerned. I think people should underline that. Practice, norms, and values of the people concerned. It will be absurd and not beneficial to the adherents of customary law if the courts were to interpret and develop the customary law in accordance with the past practices which are no longer in use. The post-apartheid judicial ascertainment of customary law has shifted from the official practice based on written precedents and now firmly rooted in the practices of the community. I've alluded to that. The living version makes customary law more flexible and capable of adapting to changing conditions of the community and thus conform to the constitutional values. It must not only adapt to the constitutional values or whatever, but also to the changing conditions of the people. Now, the Constitution recognizes customary law as a legal system that lives side by side with common law and legislation. But we shall see whether in application that is still the case. Solely for this reason, the Constitutional Court in Mailana versus Guayama case held that customary law should therefore be treated with the difference and dignity it deserves as one of the constitutionally recognized sources of our law. The adjustment and development of customary law is essential and necessary to align its provision with the Constitution and promote the spirit, purpose, and objects of the Bill of Rights as required by Section 39, Subsection 2 of the Constitution of the Republic of South Africa. However, the customary law should not be assessed through the lens of common law principles. Such an action will have the effect of frustrating the development of customary law and ultimately nullifying its recognition status and standing as an independent source of law in the South African legal system. simply replacing customary law with common law whenever there's a constitutional challenge to the former works against the spirit and purport of the Bill of Rights as far as the development of law is concerned. Now I enter into the terrain of interpretation and application. In developing the customary law, the Constitutional Court in Duplessis versus de Klerk discountenanced the striking down of customary law because of violation of the Equality Clause. The court should develop the customary law in an incremental, sophisticated, and case-by-case way, so as to progressively, rapidly, and coherently bring it into line with the Equality Clause. In Shulubana versus Namitwa case, the Concord found that the customary community had the right to develop their customary law in line with the Constitution, so enabling a woman to succeed to the throne. However, the court held that neither the sons nor the daughters of Ms. Shulban would succeed her, but a child born of the male Lamitwa bloodline will succeed her instead. So something along the line dawned in the mind of the Concord that the step it was taking was not going to the right direction. This was an anomaly which had the effect of confusing and distorting succession to Namitwa royal family throne. The court created a situation where there would be no heir or successor determined by the customary law. Baloyi Royal Council in Shulubana versus Namitwa passed a resolution on succession which was considered to have changed the customary law of succession to traditional office of host of Hosi of the Baloyi. In this case, the Baloyi Council changed the rule of male primogeniture in relation to succession to Hosi by passing a resolution allowing a woman to succeed to the position of Hosi to meet the constitutional principle of gender equality. The reason for not allowing a female to succeed to the throne is to ensure the continuity of the royal bloodline. The court was carried away with the Equality Clause without establishing the rationale for identifying males for succession. This undermines the role of customary law as an independent source of norms and values within the legal system. It must evolve within the context of its values and norms consistently with the Constitution. Now I come to the conclusion before you stop me, President Director. But we have not indicated how many minutes left. Amen? Two, why? Why all of a sudden two? I've been silent all the time. When I ask you about it now, you come about two, you come with two. Now I'm doing the conclusion anyway. Customary law must be interpreted and developed as independent source of norms and values within the legal system with its own values, not the values of the oppressors or colonialists. The Constitutional Court in Jordan and others, the Minister of Home Affairs and another just recently, has ruled that men may assume their wives' surnames and declared Section 26(1)(a) to C of the Births and Deaths Act of 1992 and Regulation 18, Subsection 2A of the regulations that barred men from doing so unconstitutional to the extent that they discriminate on the grounds of gender. The court, in so holding, it identified patriarchy as one of the main drivers of the oppression of women through gender stereotyping and abuse of cultural practices. The court went on to hold that in many African cultures, women retain their birth surnames after marriage, and children often took their mother's name. The woman retains her surname after marriage verbally, and that reference is always made to it, but not registered. That's my knowledge and the knowledge of other Africans. A particular woman who retains her surname after marriage only a particular woman retains her surname after marriage only if she is a professional and the change of surname will negatively affect her profession or business. Yes. Or a woman is also entitled to bear a double-barrel surname if she so elects, like Makanya, Sama Makanya. In my submission, that's how the court decided. Maybe there have been a consultation or a friend of court to say that is a position in African setup, which unfortunately I don't know. In my submission, the ruling by the Constitutional Court is against the grain of African customary law practices, customs, norms, and values. Under South African customary law, the taking of the surname by the women after marriage is often than not dictated to or regulated by the payment of lobola and deference to ancestral spirit. Under customary law practices, a woman breaks ties with her family on the payment of lobola, and on marriage, she assumes the surname of her husband, and so as her children. Maybe they were talking about other African people. Apparently, in my submission, there has been a misinterpretation of the application of customary law principles in this regard, with resultant confusion as to the identity of children, of marriage, and possible to succession to chieftaincy, kingship, or queenship. There will be no family tree. If a man just pry in like a fly into someone's surname, and that is taking over now. That's it. We have extended to how many minutes now? Thank you.
Thank you so much, Judge. Ndicinga uba ndiyayindisile kuba ndibona noko iminyaka noko ingathi ihambile. Ndakunika inkluva, ndakwenzelelela. Ndikwenzelelele tata. Enkosi kakhulu. Thank you. Thank you so much. Now I understand you, Prof. Ntlama. your comment that was just like this, that ended without you finishing it up. That comment of yours that I don't want to see you there, you better be here. Whatever you do it here, not there. Thank you so much. Another round of applause before I call another. Thank you. Let me call the second speaker. It's Goswayne Patterson from Cohesion and Traditional Leadership from Jeffreys Bay. The topic, the constitutional identity of customary law in modernized local government system. Over to you, Dada. Thank you.
Konkia, Dumelang, Abuksheni, Sanbonana, Masharone, Lochane, Assalamu alaikum, Namaste, Molweni, good morning, Kaitse, Kuri Tayeb Tikwadu, Ti Konske, Gakob Tikam Klapkami, Tirag Ahamikwa di Karamatai Sengusa Sip, Hotop, Kekucha, Kaire Ake. I only introduced myself in my native tongue, which is Korakobab. It is one of the unofficial languages, yet it has no other origin than this southern tip of the African continent, yet it remains unrecognized. I share the sentiments of my leader that spoke earlier on. I hail from an area called Kucha, which is on the western part of the Eastern Cape. I am the direct elect to the NEC of Contralesa, representing the province of Legends, which is the Eastern Cape. I am also the secretary of the Eastern Cape Khoi and San Council, and I also serve in our local municipality, deployed by none other than the African National Congress as a Khoi and San leader representing my people in our local council. Having said all that, allow me to greet the Honorable Chairperson of the session, our esteemed colleagues, distinguished guests, and the members of the traditional and Khoi and San communities at large. The former Chief Justice Langa once reminded us, and I quote, customary law is not a relic of the past. It is a living system of law, integral to our society, and it must be understood in its own terms and in its proper context, unquote. This insight strikes at the heart of our discussion today. The constitutional identity of customary law within a modernized local government system with particular regard to traditional and Khoi and San people. To the Khoi and San, stands as the first custodians of this land. The heritage is deeply embedded in South Africa's landscape, memory and law. The recognition in the Alex Corps Limited versus the Richtersveld community of 2003 was not only a legal milestone, but a moral one. The Constitutional Court confirmed that the rights to land were rooted in customary law, and the indigenous law is part of our legal fabric. That judgment gave constitutional voice to communities whose wisdom, traditions, and identity had for centuries been silent. It is the former President Thabo Mbeki who said in his speech, "I am an African." He said that as a country, we continue to maintain an audible silence of the horrors of a former deed, seeking to obliterate from our memory a cruel occurrence that in itself should teach us to never be inhumane again. Nkosi Langa Mavuso earlier on spoke of what needs to happen within our legal framework as a country, and he spoke unapologetically about the current colonialist system that is manifesting itself in our constitutional democracy, seeking to erase all the advances made in this democratic dispensation. The Khoi and San, we must acknowledge the painful history. From the earliest days of colonial expansion, the Khoi and San were dispossessed of their grazing land, hunting grounds, and sacred spaces. This dispossession was entrenched and formalized by laws such as the 1913 Land Act, which excluded us from vast tracts of ancestral territories. To speak today of integrating customary law into modern governance is not to invent new rights, but to restore justice that was long denied. Our Constitution, in its wisdom, does not seek to erase the past in the name of progress. Instead, it embraces the richness of our traditions and recognizes the legitimacy of customary law alongside common law. It is in this balance that we find the essence of the South African identity, diverse yet united. It's on the logo of the Republic of this country, which speaks of this diversity. For the Khoi and San people, the question of constitutional recognition is not an abstract matter, but one of dignity, belonging, and survival, which calls for the amendment of Chapter 12 of the Constitution to include the Khoi and San communities as part of the traditional leadership governance of this country, as they were marginalized, pushed aside by colonial and apartheid structures. Yet our traditions endured, rooted in consensus, community, and respect for nature. In echoing the words of the former President Thabo Mbeki in his celebrated I Am an African speech, I must say I owe my being to the Khoi and the San, to those who first tilled the land, who first named the rivers and the mountains, and who carried within our customs a philosophy of community and harmony. Today, as we discuss a place in our constitutional democracy, we do so not as an act of generosity, but as an act of injustice or justice and recognition. Section 211 of the Constitution acknowledges the institution, status, and role of traditional leadership according to the customary law. Section 39 further obliges our courts to consider international law and indigenous values in interpreting the Bill of Rights. This is where South Africa's obligation under the United Nations Declaration on the Rights of Indigenous People, also known as UNDRIP 2007, comes into focus. The declaration affirms the rights of indigenous people to maintain and strengthen their institutions, cultures, and traditions, and to participate fully in political, economic, and social life of the state. By recognizing the role of the Khoi and San within local government structures, we cannot only uphold our constitution, but also honor our commitment to international human rights standards. But my honorable members, recognizing on paper is not enough. We must ask, how do we integrate Khoi and San customs into a modernized local government framework within or without diluting our identity or undermining constitutional principles? As it stands here, I have been cited to appear in the Gqeberha High Court by an application by the DA-led local municipality seeking an interdict to evict us from ancestral land based on an entitlement that they received through colonialism and apartheid, where they believe that the land belongs to them. For us, land is not a commodity, but for them, land is power, because they know he who controls the land controls the people on the land. And for that reason, they will always try to fight any advances made in this constitutional democracy seeking to restore the land. The answer therefore lies in partnership and innovation that looks beyond racial and societal boundaries, but with an objective to not only mend the injustices of the past, but also to bring forth the so-called social cohesion required to rebuild this country. A modern local government must not simply govern the people, but also with the people. Customary leaders and communities should have structured platforms within municipalities to contribute their perspective on land use, social cohesion, cultural preservation, and community justice. For example, Khoisan San communities should play a key role in heritage conservation by advising on the preservation of sacred sites, rock art, and ancestral land. They could also participate in municipal land use planning, ensuring that developments respect culturally significant landscape, grazing areas and hunting areas, and in doing so, avoid situations like the Lisbeth Amazon project. Developments as an example. Such participation is not symbolic in it ensures that modern governance integrates their century-old knowledge and the land aligned with both constitutional values and international standards. Consider land, for instance, for the Khoisan San, land is not a commodity, but a living heritage. By embedding the customary perspective into municipal planning, we create not only legal compliance, but also moral integrity in our governance. Now, as I am about to land, consider customary dispute resolutions to emphasize the restoration and reconciliation in an era where our courts face backlogs of community cries for peace. And this ancient wisdom can serve as a modern-day solution. Honorable Chair of the session, the constitutional identity of our customary law is not a threat to modernization. On the contrary, it enriches and strengthens local government by grounding it in the lived experiences of our ancestors. To the Khoisan San, I say, your traditions, your voices, and your wisdom are not just relics of the past, but vital pillars of our democracy, present and future. Our task as the leaders and lawmakers is to ensure that the architecture of local governance reflects not just efficient service delivery, but also cultural justice and constitutional identity. Let us grow and walk this path, not of assimilation, but integration, not of erasure, but of recognition. Allow me to conclude in saying that the late Klaas Stierman first formed alliance with the Kunukwebe led by Chief Tunga, which failed, and then later formed another alliance with Amaxhosa Chief Ndlambe, and said after they achieved success to the colonialists, and I'm leaving you with these words: restore the country of which my fathers were despoiled of by the Dutch, and we have nothing more to ask. We have lived very contently before the Dutch plunderers came and molested us. And why should we not do so again if left to ourselves? Kaya yo, kay kangans. Ndiabulela, Ngiyabonga. Inkosi kakhulu.
Thank you so much. Sure, thank you so much, Tata. I know. Thank you so much. Before calling an third speaker, just touched by what you have been saying. Remember when we were still young, going up the mountains, playing up there. In my village, we have caves. We will enter those caves. One thing that is inside those caves is the writing, the art. And we will ask ourselves, where are these people? Where are they? They are there. We've seen them, but we no longer visit there. We only visit there when there is an ancestral calling to go and check on our ancestors. We go there on those caves. Without spoiling this, let me call another speaker, Advocate Mafu. Is it you? Okay. Advocate Mafu from Bishop Bar. The interdependence of customary and civil law principles within the constitutionalized framework in the legal profession. Over to you, Advocate. Thank you. Welcome, the Advocate.
Good to be here. I will start just with my topic, and my whole plan today is just to have a conversation and explaining the complex legal principles in simple everyday language that we can all understand, and something that actually relates to us. So the topic goes, it says the interdependence of customary and civil law principles within the constitutionalized framework in the legal profession. A lot of big words. Simple. The question I need to explain and we need to deal with and interrogate is the interdependence within the civil law, the procedure, and our customary law. Let me put it that way. Do I want to again? King William's down. Don't show him lima kuzilam count. Okay. Now, customary law, I see it. I go, in fact, even how I speak, I've learned it through customs. I'll sit, one elder won't speak fast, he'll speak slow, but we are manuel. He has authority. To him, he does not make the decision himself. The decision is always orientated within the community. He lives on the ground. He identifies himself with animals, with nature. They know how to work Africans. Now, so this is the African man in his own simple world. He doesn't have many laws, but everyone knows the laws. It's not written down, but this is how things should be done, and this is how things should be done. There's no form of private ownership of property. And this is a key thing. Because our previous speaker was on point, and this is where I'm going to transverse to. I want us to see this topic from an African, economical, just as a person Sambe start doing. So 1652 comes. We start Jan van Riebeck. Jan van Riebeck comes with his friends. We know Jan van Riebeck. They had ornaments that would sell to the Africans, whatever. But what we never pay attention is the laws that they brought. They brought laws. Now these laws were laws that were common to them. What we call the common law, Roman Dutch law. They come with this law. Now, at the center of this law is what we call private property. You know, hence you hear Land Act. So we have private property, but this private property is against the whole ideals of the African man. The African man has no private property. It's a usage, it's going to go for generations and generations and generations. And you must understand that the importance of the system, if you look at it from an economical perspective. When there's land, then there's a commodity you have to purchase or buy land. How do you do that? Then that's how banks are created. Banks create what we call debt. So this thing works all together. It's a system, it's intertwined. These people will create debt to have a commodity of money. Once you have that, you then have laws to deal with the trading. Hence, if one is to analyze and looks at the whole legal system, you will see from a perspective that you have company laws. So the system, let's call it the white man system. The white man system is there to benefit the businessman and the investor. How? Even with taxing, you understand if one is taxed. A company is taxed after its expenses. An individual is taxed by him. But the moment he receives the money, he's taxed. So in Africans, they were never taxed. And I'll give you an example of this. Oh, anyone have heard of Upambata? Now, Upambata fought. There was the introduction of the poll tax. That is the way that you were able to take Africans from their living, their homelands, to the towns and cities. Black people do not want to go to towns. They lived in Eslalin, they had Inkomo, they had everything, they had health. And they lived up to hundreds because they could cure themselves. Whatever they were eating was always organic to themselves. And therefore, they were always self-sustaining. They didn't need the white world. But then the white world came. We can't wish that away. But what we need to do is analyze and interpret what actually happened. So, thank you. We have, from a perspective, we now have the Roman Dutch law, which has its company laws, so on and so forth. English law comes in. The English law comes with the procedure. It determines the courts how they must function. But what was a key thing was that both the Roman Dutch law and the English, when they made laws, their laws excluded the black people. And this is key. So their laws were economical in nature. The Roman Dutch is about trading. The English is about regulating the courts. Now, my constitution, just hold this. I want to go to the constitution. Now, how does this tie in with the constitution? If you go back to the Land Acts, you understand it's those dispossessed black people of rights. You go to the 1940s when the apartheid regime took over, the 1961s. There again, those systems excluded black people. Now, we fast forward to 1994. So we have two systems. These people all excluded black people. Now in 1994, we have a constitution. Now, this constitution, again, if you remember what I said, customary law is all orientated about people. It's orientated ngabantu thina. Whereas English law, Roman Dutch law is fixated about the economy, about the money. Now, in our preamble to the Constitution, we then give it a human face. We give it values. Hence, we say Ubuntu. These were not values that were recognized with the systems before. The Roman Dutch people do not deal with this, neither the English. It is it's a purely African concept. See it. It's just a word to explain our values. So in a preamble, we say, we, the people of South Africa, we recognize the injustices of the past, honor those who suffered for justice and freedom on our land, and respect those who have worked to build and develop our country. believe that South Africa belongs to all and infinite. And it continues. Come on. But at the core, this constitution then has what we have, rights. And if you look at these rights, they're actually as rights to counter the oppressiveness that was created by the other systems. So as people, we need to understand, and how do we use ourselves? Because as this is a funny thing, is that we try too much to assimilate. That's our biggest problem. We always try to assimilate into a system, a white system. That system already rejected us. Just love ourselves. And once we understand ourselves, we understand the greatness of ourselves. We understand the value systems. We created many things. I mean, we didn't have hospitals. And this is a difficult concept to understand. We did not have hospitals. Why? We didn't have cancers. We would deal with them in society and we come back. We had these systems there too. And those systems did not mean many laws. And if one is really to interrogate those laws, it's trading laws, company laws, it's to protect your private property. So in essence, is to say to our leaders, you are the future. You really are our customary leaders. It might take the beautiful ones to understand it, but the majority of people who don't understand it, there will come a time that they will understand it. You are the custodians of the land, always have been. You don't need someone to pronounce that. You have to take care of this land for future generations, and you must be able to put in the ideals and the beliefs of black people to the forefront to be able to advance society to a better place. And that's all. Thank you.
Thank you so much, Wathetha njengomfana omtsha. You were just short. Thank you so much. We had our own system. You spoke about Ubuntu, you spoke about so many things. I'm thinking about umunwane. Do you still remember? Umunwane. Umunwane, we used to do simbet, iltyeni, simfake ebhotleni, senze drink kamunwane. That was medicine, the original one. That's why we were not getting, those old people, they were not getting sick. Even when we were still young, we were not getting sick. But if I can tell you now, how many tablets we take a day. So thank you so much. Another round of applause from our advocate, Mafu. Let me call another lady here, Dr. Zamambo Mkize from the University of Cape Town, Doc. The topic is saying feminism and the right to gender equality in a polygamous relationship. Wow. Over to you to talk. Thank you.
Thank you. Good day, everyone. I just wanted to say thank you to Prof. Nhlama Makanya for inviting me, and the Dean, of course, and for putting together this colloquium, and for the university for hosting it as well. So I'll be as quick as I can. I'm so glad that I'm going last. So I always use this picture to introduce my students when we talk about this topic, and I always say to them, what do you see? So in the interest of time, I'll tell you what I want to really talk about. So as you can see in this picture, that this is clearly a negotiation of some sort, and looking at the body language of the African man, he's bent over, he's a bit hesitant, unsure, and the colonizer, on the other hand, looks very confident and sure and happy with himself in that he got everything he wanted in this agreement, and his colleagues are also very happy and content, probably from all the looting and stealing or making their way down to the tip of Africa. And I always say the most important thing is that this clearly is a negotiation that's happening here, and that the Africans brought a woman to the negotiation. So what does that tell you? It shows you that obviously we've always seen women, African women, as important, as significant, as equal enough to be brought to a negotiation of this sort, which shows that African women in pre-colonial eras were political leaders, spiritual leaders, they were military leaders. People went to them seeking guidance, advice, business acumen. I mean, these women were warriors. They protected gods and kings and honorable men. So women, for us, have always been equal. But it was when they came here that they told us that we are not. So I think it's important to look at definition of terms, of course. When we're talking about poly comes from the Greek word meaning many. So polygamy is an umbrella term. So most of the time when people talk about polygamy, they're actually talking about polygyny, which is that one man can marry many women at the same time. Then there's polyandry, where when one woman can marry many men at the same time. Then there's group marriage, where it's several husbands and several wives all together. And then there's polyamory, where it's several people dating each other. The last two, I don't know anything about. I don't know. Last time someone told me about it in the Americas, white people were doing that. I don't know anything about it. All I know is the polygyny, because that is my area of expertise. So I wanted us to look at this map and the polygyny practices across the world. As you can see, that polygyny, the red is that it's illegal, and then the blue is where it's polygyny, where men can marry more than one wife at the same time. Then the sort of lavender purple on the African continent, I think that's Equatorial Guinea or Gabon, I'm not sure, where polyandry is also allowed. And then of course the blue being us is that we obviously do recognize these unions under customary law. So when we look at polygyny internationally, we have the Convention of the Elimination of All Forms of Discrimination Against Women, which wants to eliminate all kinds of discrimination, and they view polygyny as being a discrimination. And of course, the international human rights provisions aim saying that there needs to be equality for spouses before and after marriage. And of course, African Women's Protocol says monogamy is the favored form of marriage, but women in polygynous unions must be protected and not be disadvantaged. Our Constitution, the Bill of Rights, states that everyone is equal before the law and has the rights to equal protection and benefit of the law. Equality means full and equal enjoyment of all freedoms. So the state cannot discriminate based on race, gender, culture, ethnicity, and social orient. It goes on. So then the question is that polygyny, is it contravening the Section 9 of Bill of Rights if a certain group is allowed a privilege based on their gender and race and other groups are not afforded that same privilege? Thank you. That is the definition of discrimination, right? So polygynous unions in South Africa on the surface do look unconstitutional because, well, the Equality Clause supersedes the right to culture. But why won't the Court ever declare it unconstitutional? And I think, we're in a room of learned lawyers and advocates and judges. I think they know the answer to that question. So when we look at equality within the law, the law sort of tries to, it recognizes that yes, it is unfair, but tries to put it in line with the Bill of Rights by having the recognition of Customary Marriages Act, in that if you're going to be in a polygynous union, there needs to be consent, both spouses have to be equal, minimum age, and all other provisions that they have. And also that the marriage needs to be registered, as well as other ways to protect the woman in this union. So the most important thing as well is consent. So African culture and the law are very clear that in order for a polygynous union to happen, the man has to seek consent from his first wife. But what is consent? A man can go to his wife and ask to take a second wife, the wife can say no. The man can then embark on a campaign of forcing, coercion, bullying, emotional blackmail from his relatives, from his wife's relatives, from society at large, to get her to change her mind. And then when she does change from no to yes, so technically it is a yes, but then what does that mean if it's coerced? So what about the disharmony, the resentment, the ill will that breeds, not only individually, but also in the family and spiritually? So now men can go ahead and get married, and some do, even if the wife didn't consent, but those marriages are not legally recognized. Legally, I mean, they're not, and also culturally as well. Few women have fought this battle, some successfully actually, some don't want to, and some don't even know that they can even fight this. So then what happens? We live in a society where we have situations like this, modern polygyny, where as humans, of course, anything with humans will always convolute it and change it to benefit themselves. We live in an age where personal and private and sacred matters such as marriage are put on TV for entertainment purposes. And it's fine to put cultural practices on TV. If it's going to be educational, then there's nothing wrong with that. But the issue then becomes when the cultural practice is practiced incorrectly, and then it's put on TV, and then people are watching it and consuming it, such as Uthando Nothembu and Sister Wives and all these things. And then what does it mean then when you're putting on shows where we show a practice that's being done incorrectly, and we're showing African women's pain and heartbreak? And how is that entertainment for us? What is that saying about us, that we're consuming this and we're okay with this? So the question is there feminism and equality in polygyny? Well, the law is clear. It tries to protect the spouses within marriage by having requirements, stipulations that the man must adhere to, and for these marriages to be legally recognized, and of course consent being a big thing, and the big issue is registration of the marriage. Culture is also very clear in that for a polygynous union to occur, the consent of the first wife must have happened, which then actually shows then who really has the power in that relationship. This not only speaks to Africans' culture, fierce expectations of respect, and to also follow traditional cultural practices properly, and if not, of course, the man will have to pay damages not only to his wife, but to his wife's family, and also to the ancestors by not doing things properly. So I did my master's and PhD in polygyny, and I published my first book titled Polygyny and Gender, the Gendered Narratives of Adults Raised in Polygynous Family. And I was very surprised to learn not only about the practice of polygyny itself, but that modern educated and financially stable women willingly enter such unions, and also to also learn from the adults who were raised in such unions and their perspectives and how it shaped their gendered identities and individual beliefs. So as an African feminist, I always say I'm always for African women and African traditions and cultures that not only uplift, but also protect African women. Because as I said at the beginning, we've always been equal to men, because men are a part of us. They are part of the human race. So they can never be the enemy to us because we are one. So that's why we've always been equal. So thank you.
Thank you. Thank you so much. Men are part of us. I love that. I love that part. Men are part of us. I was joking with my colleagues there that it's nice to have a man next to you, because you turn this side, it's this side, and you turn this side, it's this side. You go at the back, it's this side. So that's what is nice, to have a man next to you. Okay, colleagues, thank you so much. Let's give him another round of applause before we go on questions. I know that the time is against us, but thanks to colleagues. We would like to ask a few questions. I know colleagues down there, they've got questions because of this interesting discussion that we're listening to. Colleagues, any questions? Tata?
Mandikhahlele ndibhodise kumntu wonke kubantwana begazi. Okanye ke mandike ndiwele. Mandiwele ndiye ku-Elizabeth. With the understanding that uNkosi uMininkulu uJoyi owasemthatha eBhazia. Kahle kahle bengamelanga bandithi Joyi. I understand bana kukho lento eyasondela nabangapha ngaphesheya that you would have a name and a surname. But actually pre-colonial it was Mininkulu Kangwenyati, of which Ngwenyati is my father. So I actually had an issue with the judgment, the court judgment, but then I backtracked and remembered that no man, this thing of surnames was colonial. It was brought to us, so I shouldn't be worried. Rather, maybe I can change and say Mininkulu Kangwenyati at Home Affairs, if so. So, my daughter, ninga change. But where I'm going at, as we are discussing decolonization, please, can the panel maybe assist me into understand, because if we start the discussion of decolonization, are we then not saying that we will also decolonize the annexation of the country, being South Africa? Because we understand that the constitution is based on the context of South Africa. But me being Umthembu, I've got my customary law that speaks to the customs that we practice. Are we not then going to then say, Abathembu need to be a standalone, where they got their own laws that cannot be brought to the national context? I know it would sound as though now I'm poking at patriotism or nationalization, but there's that thought that is pricking my mind consistently as the panel discussions were going on, that maybe we might even then start considering the idea of the South African agenda, which is the annexation of the country by the colonizers. Thank you. Diabule.
Thanks so much. That case which we have, well, with Amazon at Lisbeck Park, as much as Judge Sportain make a court ruling with regard to say that no economic consideration can override the right of the indigenous people of Africa, yet we still lose that case that against them. I would like also that seeing that we have that our judges here as well, to look at that and give us an explanation why we were even able to spend so much time. We were almost killed actually, and yet the court make that a determination, and still that we lose one of that case, because yet what the judge was saying, no economic consideration can override the rights of the African people. Thank you.
Manibulise. Luthethayo nguChulumanco waseKhimbile emampondweni. Ndicela uqale ndithethe nje into endihluphayo. Silapha ngento ye-customary law, kodwa anikhumbuli kukhona inkosi yalomhlaba sikuyo eke yaphakama yathi masikhahlele ikumkani esizwe. Ngokwapha emampondweni ke indelelo leyo. Awukwazi unofika pha emampondweni ungamkhahleli uDaluxolo. Kuba ikumkani ekhoyo. So ndiyirhalela loo nto uba noba sendihleli phansi noba kunini siyinike loo mbeko ikumkani yesizwe. Ndiye kule nto singayo namhlanje. kukhona le phrase isetyenziswayo consistently apha ye-equality. And I've always, Mthembu, njengawe, I've always had a question ngaloo nto, but what is being made equal to what? And I like the fact that uDoc uyithethile into yokuba as Africans, we've always been equal. And we had this discussion phezolo no Professor during our meet and greet nangobe siye hotel. And I was saying to Prof, the interpretation in today's time, equality, is for us to bundle all together in one duty or space or whatever. So an example of that is this, khona isithethe namhlanje besithe, I think sisuke bathe nje naso simele uNkulunkulu. Sike sathi, kulanto yokuluswa kwamakhwenkwe, kukhona irole edlalwa ngomama, ime. And then there is a role edlalwa ngotata. That is equality. In order for that ritual to be performed, that is the equality in separation of labor. Because if we do the same thing, we will not achieve as much as we aim to achieve. I then say this. Kukhona nesinye isithethe besithe we are assimilating. Ndiyithethile ngaphezolo kuProf le nto ndisithi we are fighting wars that are not ours as Africans. Feminism is not our fight. I'll highlight a speaker from America, Sir Jonah Truth. When feminism was being initiated or conceptualized, Sir Jonah Truth, who was a housemaid to a white household in America, when the white women, because they were really disadvantaged, they were not allowed to work, they were not, 5 minutes, they were not allowed to work, they were not allowed to work, they're not allowed to do anything, they couldn't even raise their own kids, they had nannies for that. So that's where feminism that's what motivated feminism, because they were rendered useless. So when Sir Jonah Truth entered that room to say, we as black people also, black women also have our plights and our own challenges, she was not allowed. Hence there was that speech that said, am I not a woman, by Sir Jonah Truth. I say that to say this. There's a kingdom, there's a queendom in South Africa. The Balobedu Queendom. The queen apparent to that queendom is being contested by a male. Now, culturally, the Balobedu people are not ruled by males. They are ruled by females. Now, I have a problem with this equality thing because that man will ride on that equality way, his own culture, his own custom. So I need this panel to explain to me exactly this term of equality, because I even noted it when the speaker or advocate was reading the preamble of the Constitution, and Doc also read a part about equality. It does not speak to say, what are we equating to what exactly in the context of our cultures and customs, and how we do about the order of succession. Now it's being distorted all in the guise of trying to make one equal to another. What are we equating to what? Thank you.
Can I give the mic to anyone to respond to the questions posed?
If I may add to the last gentleman's question of equality, I was having a discussion earlier on with Nkosi Mavuso relating to equality, and I was saying that how is it that our customary law supersedes any other law, including the Constitution, and our customary laws dictates a sovereignty of some sorts, where you have a traditional leader that is not equal to the rest of the community. Now, how can equality exist in a setting where the law that used to govern the land in customary law did not render us equal in nature? So from that premise, I only wanted to add this. I'm not schooled enough to answer on feminism, and I will leave it to Doc here. But I just wanted to add this in saying that in its nature, equality should not have existed because it nullifies our advocacy with respect to traditional leadership and traditional communities.
And I just want to give a counter argument. Yeah. As a lawyer, we have to sometimes, we need to test things. Yeah, we retest them, we check them out, we interrogate them. By interrogating them, we have a better understanding of them. I want to start with the chief and begin with the king with decolonization. I'll start off just by the wrong answer. I say it's the wrong answer. And that was Fanon. Fanon had looked at decolonization from a Western perspective, and he said to decolonize is a violent phenomenon, and he he went for a violence, saying a revolution. I don't think we have time to revolutionize, but I could be wrong. Where I want to go at is this. If we recall, the Constitution was made as an antithesis to an anti-black system. Yeah, if we look at it from that perspective, the system did not want black people. So the Constitution, then trying to merge it, it says, no, let's use this, what we have, this clause called equality, because at the stage, that's where I agree with my brother here, black people were not seen as people. Let's look at it, let's understand from a practical perspective. If I say to you, if my brother says, hey, I've got a heart injury, I won't be able to, I won't want to cut him myself. But if it was a rat, I can always examine on a rat. So that's how white people saw black people. Where I'm going at is, they didn't see us as people. The only way you had to force them is by law. Yeah, well, that's what I'm going at. The equality clause is there to force them by law. It's like asking someone who's a racist not to be a racist. He can't. Yeah, but if one is understood to pedagogue of the oppressed, you read Paulo Freire. Paulo Freire speaks about it. He says it's the oppressed who are able to, the oppressed are the ones that are able to liberate both the oppressed and the oppressor. The oppressor is unable because he was unable to see the wrongs in the first place. Yeah, but the continual oppression he was doing, he could not see it. Yeah, but so it's for us to understand, and we need to get out of these big words, and see things for what they are. Because as strong as land, we already have land. And if you understand, even from, and my brother was correct, he who controls the land, he controls the economic superstructure, the ideals, the thoughts, the philosophy behind. So as a core basis, the values and philosophy are already intertwined within the Constitution. We just need to embody them on a day-to-day basis. Once we understand on a day-to-day basis, we'll be able to understand, or actually to interrogate and see these laws for what they are. No, not for what they tell us to it is. Yeah, well, we told a lot of things and we listen too much dogma. As opposed to the pants abantu bakudala. Abantu bakudala bahlala phansi bathethe. Bayijonge lento lena, bayilalele, and they'll come back the next day. So we have everything at our disposal. We're trying to resolve it in an academic way, in a legal way, in an intellectual way, big English. It's communicating. Just use them and benefit our people. Thank
you. Thank you. I'll respond to what the king or the chief, the king, goes. Inkosi kodwa-ke kuba khona umehluko, khona ikumkani, khona so now you want to take your Batembu land away now. No, we're not intimidated, but I want to show you something. You remember that how the colonialists defeated us because we are not united. One time, at the time they were fighting one, other people were looking on and waited until they came to them and defeated them as well. All of us were defeated. So if we are going to adopt the same attitude, we are not going anywhere. It's a time now that we unite and restore our integrity, our dignity, and everything that belongs to us. There's nothing wrong in our culture, there's nothing wrong in our laws, but now we have to think differently. And also, we should not confine ourselves to culture. There's commercial world. We're not exposed to those things. People are busy from abroad, exploiting our economy, doing all kinds of things. With us, we are only concerned with our culture and all those things else there. The culture of the hungry people. So this land belongs to us. Even the minerals coming out of this land belongs to us. So if you are in Batem, we don't have a gold, we don't have a diamond, and other people, Bafokeng, they have a diamond and all those things. Those things will belong to all of us, will benefit all of us. But if we are segregated as the brewers ordained, I don't think we achieve anything. Thank you.
Thank you. Thank you so much with those kind words. Somebody notified me that there were hands. Can I take those, Prof. Klama? There are few hands there. Okay, thanks, Prof. Two hands, okay. I've noticed two gentlemen there. Oh.
Molweni ke. My name is Kaile Tumqalo. I'm the chief of Amakuze here in Alice. Very much unfortunately, most of the questions that I was to ask have already been addressed. But at the same time, I'm very much interested in the question of the succession by the females, while there is a male existing in that particular home. I don't dispute that, and I have no problem with that. But one problem is this, that is she going to be a successor or the regent? Because there is a line, there is a lineage. Then when he gets the child from another family, we are not in Europe here, we are in Africa. And at the same time, I think that it is not the property, it is not the issue between the two people, that is the family and their children. But the community has to be considered as to whether they would like to be controlled, to be ruled by the female. And if at all say the law forces that is no longer a law, it's a discrimination. Therefore, I'm very much interested in that as to whether Zwelandile, Ntomesizo is very bright than Zwelandile, my son. And is very much concerned about the chieftainship and will protect this chieftainship. But what about the people, the consent of the people of Mamakuze? Number two, let's come to the initiation. For me, to my experience, the multi-death which is happening in the initiation is the question of age. Because I started to be a man, to enter in that passage when I was 20. And no Kangata or such traditionalness would bully me. Because I was responsible for my life. You can't take a person of 16 years who is not responsible for his life and take him for the initiation and think that he might come. He might come alive, or he can be dead because he's not responsible for himself. Lastly, Section 25 of the Constitution protects the property in the Bill of Rights. It protects that property after the property has been dispossessed from us, because the colonial did not come with the cattle here. The only thing to Section 25 of the Constitution should have done is to restore the lost property or the property which was dispossessed, not to protect it. Thank you very much, Chairperson.
Thank you. Just one now. Just one, please. Yes,
Thank you
take
very much. My name is Future Ngube. I also want to ask, but I was partly captured by one question, one speaker. I want to ask, how do we ensure homogeneity of cultures, given that there are various cultures that we are talking about, maybe call them customs? How do we ensure homogeneity? For example, we speak of official customary law, we speak of living customary law. Even before we get to Abatembu, we get to various other houses. Maybe at the end of the day, it will teach another to say, of course, we spoke about customary law, all of us, but this one belongs to, it's for us, Abatembu, and then to the exclusion of others. How do we ensure, this is a quest for consolidation of customary law, but at the end of the day, how do we then ensure homogeneity of that? And what does it start and end? The issue of modifying customary law. Do we go back to 1652 and start wearing or eating roots
Thank
and
you,
other
thank
things that
you.
were being eaten?
Summarize,
we go to 2008,
Sikume.
or where do we start?
Thank you, Stikuma. There are 4 questions here. I'm sure Judge would like to.
Okay, thank you. Well, I want to answer that question relating to a female succeeding on the basis of equality. There's nothing like that. The customary law says only the male should succeed. Not because the person is a male, because we want to ensure the continuity of the bloodline. That's where the Concord messed up in the case of Shulubana. And Midway realized that it's gone wrong, because they say neither the son nor the daughters of Ms. Shulubana will succeed. Why? The only person who should succeed is that a male of a bloodline. But having caused a mess, because now postpone the dispute to the chieftaincy and all those things, causing a lot of unnecessary problems. Unless, if that family does no longer wish to continue as a royalty, they can sell it away to others, as now they are going to take the surnames of their wives. So the person who's Mtembu, who's not Mtembu, can now be Mtembu and inherit. It's not. It's a misnomer if that is said because of equality, or people are just carried away by equality, even if it's not appropriate. Thank you.
I think, Prof.
Okay, thank you, colleagues. I don't want to monopolize this event. As I've just said, I don't want to monopolize the event. Justice Matondo has just explained why no to women. That paragraph 90 of that judgment endorsed that a sociological child. Women might be celebrating that, yes, the institution is transforming. No, there's no transformation there. We can still make a case under that concept of a sociological child, which means now the throne goes back to who? To a man. So there's no transformation there. There's no celebration at all. And the throne is not an inheritance. The throne is about the status of that community. You can fight about family property, is fine, you can do whatever. But not the throne itself. One other thing, I'm glad the judges are here. But they are not going to respond to this. Why? Because the judges, they speak only in court. They don't have to justify themselves here. And they are not subject to public opinion. Because they are the determinants of how to put wheels into that constitution. Where I'm driving at today, we are sitting with the former president of Zambia at the mortuary, waiting to be buried. Yes, we're waiting for him to be buried. Why? Because of these clashes. Because no, he was the former president. But now the family wants to bury their husband, their brother, their whoever. But the judges, please, don't respond. Don't respond. Because now the academics and the traditional leaders, they are expressing their views, they are being persuasive to the judges on how they should do tomorrow. As I've just said, they speak only in court, not here. They are not going to justify themselves here as well. So, but I'm glad that they are here. So that is why there's a diversity of the groups that are here, so that we reshape the interpretation together. So we are all in the same path, in rebuilding or towards a reorientation on how we can use that constitution. It's in influencing our own way of living. That time of whining and complaining, I think that has come to an end. Thank you very much.
Thank you so much, Prof. The time is. Thank you so much. Colleagues, let's give a round of applause to our speakers here. And I know that we are running behind time. Prof, let me give it to you to give us a way forward. Thank you so much.
Colleagues, let me not deny you the right to food. In fact, it's not the right to food, it's access to food. So now, colleagues, it's 5-2. Just a minute, colleagues. Now it's 5-2, and the lunch is upstairs. So let's go and have lunch and come back at 2:20. Yes, we'll come back at 2:20. And when we come back, just a minute. Session 1 after lunch will remain here, and the other 2 sessions will go across at the BS gallery. Thank you, colleagues. Yes, this is panel 2. Yes, panel 2 must, just a minute, colleagues. Panel 2, who are supposed to proceed from this session, will come back here, so that we proceed with them here. Then the other panels, they go to the BS hall, so that those ones will be different sessions. Okay. There will be parallel sessions in DBS. It's the continuity. That's why we're
afternoon, everyone. My name is Shandukani Mtugulu Goda. I'm a lecturer at the Faculty of Law at the University of Fort Hare. It is my privilege and honor to welcome you to this session under the theme, Placing Customary Law in its own context. I would like to, so that we save time because we are really behind, I would like to call on the panelists for this session. The first one to come to the fore. The first one is Dr. Wilson Carrera Mbugua from Kenyatta University, that is from Nairobi, Kenya. A round of applause for Dr. Wilson. Dr. Wilson's topic is the effect of codified customary law on living customary law. The effect of codified customary law on living customary law. The second speaker is Neo Mutabo from the University of Johannesburg. Neo? It's not here. Then we'll move on to the next speaker, who is Maibongwe Takawira from the University of Fort Hare. Maibongwe Takawira? Oh, okay. Then let me call upon Nokaga Jumba from Congress of Traditional Leaders of South Africa. A round of applause. So the topic is the codified legal framework and its contribution to the dynamic nature of customary law regulating the institution of traditional leaders in South Africa. So I only have 2 speakers in this session. All right, over to you. We'll start with Dr. Wilson Carrera Ugua. Over to you, Doc. colleagues, we're just waiting for the other colleagues who are in DBS. They are working here. Then we will start in the next few minutes. Prof. Msinyana, we're going to start in the next few minutes. Please bear with us. Professor Msinyane, can you hear me?
Yes, I can hear you.
We're going to start in the next few minutes.
All right, thank you.
All right, sorry for the inconvenience.
Not a problem, not a problem.
Welcome, everyone. We really apologize for the inconvenience. We have noticed that
some of the presenters are not here, so it's better we combine all the 3 sessions together here. So we have presenters from the theme Placing Customary Law in its own context. We have got Dr. Wilson Kerera Mbugai from Kenya University, Nairobi. A round of applause. Dr. Wilson's topic is the effect of codified customary law on living customary law. Maybe before I call the second speaker, I should introduce myself to those of you who were in the other venue. My name is Shandukani Mtuguru Goda. I'm a lecturer in the Faculty of Law, University of Fort Hare. Maybe I should properly greet you as an African child from the Venda tradition. How we greet?
Da.
So this is how we greet in the Chivenda culture, more especially if you have traditional leaders and royalty in the house. Thank you. The next speaker is No Kaka Jumba. And then she's from the Congress of Traditional Leaders of South Africa. And then her topic is the codified legal framework and its contribution to the dynamic nature of customary law regulating the institution of traditional leadership in South Africa. A round of applause for And then we have speakers from the theme, the effect of constitutionalism and customary law. The first speaker is Innocent Chigume from the University of Fort Hare. And then his topic is navigating gender dynamics in African customary law, a path to equality. Innocent? It looks like he's not here. The next speaker is Mr. Gudani Chikota from South African Chair on Equality, Law and Social Justice. That is from the University of Witwatersrand. Mr. Chikota, are you here? Mr. Chikota's topic is In the Name of Manhood, Reconciling Culture and Queer Rights in Ululwako through Ubuntu and Decoloniality. The next speaker is Fanele Sibongwe Zwane from the University of Fort Hare. It's not here. Then we've got Professor Boitumelo Msinyane from the University of Northwest. He is online. Welcome, Professor Msinyane. Professor Msinyane's topic is a critical evaluation of state regulation of indigenous African knowledge system. Welcome, Professor Msinyane.
Thank you.
Then we have got speakers from the theme Reform of Customary Law in a Constitutionalized System. Ms. Samantha Buckley from the University of Witwatersrand. I don't think she's here. Then Sikulule Lebukani from the University of Fort Hare. No sign. Maibongwe Takawira. Not here. Donald Mukwebo. Not here. Asanda Mbolambi from the University of Fort Hare. Their topic is exploring the viability of lobola as an option for addressing inheritance rights posthumously and artificially procreated children. A round of applause for Ms. Sibulelo, Advocate Seti and Asanda. We have Professor Lawrence Juma from the Rose University. I didn't see him. Is Professor Juma here? Okay. Without wasting time, I'll hand over to the panelists. A round of applause to our panelists. We'll start with Dr. Carrera.
Good afternoon, everyone. All protocols observed, I am excited to be here, particularly that I'm walking on my feet at a UNESCO declared site. And in the presence of chiefs. You know, the previous speakers were talking about royal blood. And I think I've had an interaction with the chiefs, and I'm delighted. It's beyond words. When I got this invitation, I didn't even hesitate to say yes, I should be here. So now, without wasting any more time, or rather without any further ado, let me proceed with the topic. And one disclaimer is that it's going to rather overlap in some of the topics that have been mentioned by the previous speakers because of the nature of the topic, because it's talking about codified, the effect of codified customary law on living customary law. So here we have two intertwined issues. What is codification in the first place? And then what is living law in the second place? So when we are thinking about codification, what is codification to my mind and to what scholars think codification is? And according to scholars and what we know is that codification is what we think is maybe a piece of legislation or maybe enacting a constitution. So what is that going to do to the same living law, customary law that we are talking about? In the first place, the first argument is codification of customary law. How does that happen? It's probably going to be through when a parliament has passed a bill or when we are enacting a constitution. And what is that going to do to the living customary law? That is the first part. And then the living customary law, does it transcend through various generations? Does it apply to Generation Z, or as we call it in Kenya, Gen Z? Or is it Generation Alpha, now the upcoming generation, or the baby boomers, if we put it like that way? So then this question tends to be a bit complicated, and so codification may take various forms. For instance, Justice Madodo here was pronouncing laws, so maybe how has he pronounced himself in matters of customary law? So that is one way. The other way is now through the parliamentary system, where the parliament passes the law, and then we have now the constitution. And now let's go now to the process of legislation. How does legislation take place? Do they invite a consultant? Who drafts the actual law? Do they have the inspiration of understanding what customary law is? Maybe, maybe not. So look at even the wording of the various constitutions. I'll take comfort in giving the example of Kenya, where I am from, and how things are done there, or rather how the constitution has been enacted. So you look at now when they are setting up we did our constitution, and I'll give an example of Article 2.4 of the Kenyan Constitution that talks about that any law, including customary law, that is inconsistent with this constitution is void to the extent of the constitution. Inconsistency or omission or in contravention to this constitution is invalid. So it means if we have a valid customary law that is in place, and it has been deemed to be inconsistent with that constitution, then where does the customary law language, the drafting of that language is a bit friendly. The pre-colonial, the customary, the constitution that was before then would use words such as repugnant. You know, that's a very strong word, something that is repugnant. What does it mean? Perhaps something that is repelling, primitive, or in any other way that can be interpreted. That is what the colonizers drafted their constitution to look like, because they, for one, they never understood what customary law is. And going back to why they did not understand this, I remember the previous speaker spoke about community land. They never understood how a community could own a piece of land. That was a foreign concept to them. So to come again and appreciate the essence of a community owning a property was non-existent according to them. Then they also did not recognize marriages, the kind of traditional marriages that were existing. So the other challenge that befalls on anyone when we are trying to codify this customary law is the diversity of the different communities that we have. What does that? We thrive in diversity. We are not a homogeneous society. So what does that do to customary? If you attempt to codify the customary law, I don't know how many ethnic groups we have here, but I would take the example of Kenya. We have about 44. So if you attempt to codify that, I don't know what kind of document you would have. So there is need for flexibility for that. And again, we are progressively realizing that our laws are not in touch with realities, so that is now the living law part of it. For instance, now the Marriage Act in Kenya recognizes polygamy. However, the Penal Code is still in the colonial drafting, because bigamy is considered as a criminal offense. So you have, on one hand, you have codified the fact that you can have more than one wife, that is under the customary law, and the different ethnic groups. But on the other hand, it's not in touch with the Penal Code, because the definition of the crime bigamy is going through a ceremony when you have a previous existing ceremony. So does it mean if I have an overzealous prosecutor who is seeking to perhaps prosecute someone simply because they have taken a customary law, then that leaves the question for you to consider. So again, going back to the drafting process, for the most part, I consider this, I can argue with this using the theory of legal transplant, that most of the laws that we have are either inspired by common law, westernized kind of laws, and these laws do not appreciate the current situation on the ground, that is now the customs. So we have external influences. Let's say you'd see you have donor funding, or rather an organization like the World Bank would tell you, do away, as part of the funding conditions, do away with a particular law simply because it does not conform to what they consider to be the proper norm according to them. So this person who is tasked with this task of drafting would come up with a law that would, because it has borrowed from this template. And we have also seen the advent of model laws, particularly in all spheres of law. You've seen where organizations have come up with model law, and a country is considered to be ticking all the boxes because it has adopted that model law, which may not, if I use that theory of transplant, may not, it's like when you're doing an organ transplant, you'd have to go and do a battery of tests on this particular patient, lest the patient will come off in a bad situation than it were before they did the transplant. So we have situations where you have these so-called transplants of laws that are not in touch with the reality on the people that they are meant to govern. So with those few remarks, I think I conclude with that it is difficult to codify the customary law because it's evolving. So what the previous generation used to observe as customs perhaps has not been passed on to the other generation. So and I think I'm being informed that my time is up. and I thank you, everyone. I'll take questions after this.
Thank you, Dr. Carrera. The next panelist, we will take Professor Musinyane from the University of Northwest University. He is online. He will be presenting on the topic, a critical evaluation of state regulation of indigenous African knowledge system. Welcome, Professor Musinyane. Can you hear me? Prof, can you hear me?
Can you hear me?
Yes.
Can you hear me now? Yes.
Yes.
I can hear you. Thank you.
All right.
All right. Is my screen shared already? Or?
Yes, you have 10 minutes.
Oh, it's no longer 15 minutes. Thank you. I'll try to be as quick as I can. Colleagues, good afternoon for everyone who's there. I've already been introduced, so the 10 minutes, it's a short time for me, but I'll try to be as quick as I can. I see that the slide is taking a bit of time. I'm not sure if you can see it on your side. The topic is just amended a bit, just to say it's a critical evaluation of African state regulation of indigenous knowledge systems. We've just heard the previous speaker now talking about whether is it practical for us to use our own governance systems, for example, customary law, or the fact that we have too many different nations, are we able to actually do that? But the question maybe that I need to ask or pose using my presentation as well is it really the reality of our ways that we can ignore the 44 laws that kind of tribes, laws that we have, or we should just really enforce the Western law as it is? Colleagues, I'm sure you know that out of the 55 independent states we have that are divided into 5 geographical regions, majority of them obtained their independence in the 1960s, while the only 8 obtained theirs in the 1970s, Zimbabwe only in the 1980s, and then South Africa and Namibia in the 1990s. So if you calculate the years that Africa has been independent, it starts from 64 years of independence, 54 years, 44 years, and 34 years of independence. Now, if you look at this, now there's a lot that actually needs to find and determine as to the extent to which these African countries have embraced their own meaning of independence, looking deeper into their governance systems. I'll keep on talking because I don't know if it's sharing on your side. Now, if you look at what is it that I need to present today is to a critical evaluation of the governance systems and how indigenous knowledge systems have been marginalized by the same African state post-independence, while promoting Western governance systems, cultures, laws, languages, and the healthcare system. That leaves a lot, to be desired as to how these African countries have glamorized Western governance system to the detriment of their own knowledge systems and governance. Now, if you look at the colonial history itself and seeing that how many European states actually colonized Africa, one state managed to colonize over 14 to 12 states at a go. And all of this that after they have left, all of these countries, if you look at them today, you will really begins to wonder whether are we actually enforcing our own laws, or are we actually just obliging to fulfill or to, or to beg or to follow our colonial masters. Their constitutions, all of them, their cultures, their languages, their law still mirrors mainly the Western governance system than indigenous knowledge systems. No state in Africa has actually embraced and protected its own indigenous knowledge systems, and even to govern the affairs and its people. This has really promoted, profiled, and developed colonizers' power, control, authority over the indigenous knowledge systems to date. If you look at all the governance systems that the colonial systems have left, they used mainly the law as a tool to infiltrate and to weaken the African knowledge systems, develop systems aimed at destroying and undermining indigenous knowledge systems. Now, how did they actually use the law in this instance? The kind of laws that you find today, the kind of laws that actually, in terms of language, in terms of culture, in terms of healthcare, in terms of engineering, in terms of science, they all mirror a Western system to the detriment of the indigenous knowledge system. For example, let's take the healthcare law. Remember during the COVID, Madagascar, promoted and used its herbal medicine, as a basis. And the World Health Organization was quite quick to criticize Madagascar about how they can really not, risk the people's life by using untested remedies. And if you look at the standards that they are using a Western standard that everything that needs to be in terms of healthcare needs to be, approved, needs to be tested. But what about the knowledge system that the country actually had? We move to manufacturing, for example, the aviation laws. The kind of laws we have today mirror mostly the Western system than the African system. A typical example is the Daniel Chingoma, which is the guy in Zimbabwe who at this moment has, developed and manufactures helicopters. But the challenges that they actually look there, they are not really African per se, but they are more into Western because the law that is there mirrors probably mostly that. Now, law here is quite critical in terms of regulating how these post-Africans, independent state regulate themselves, run themselves, and the languages. If you look at all the languages that African states are using, official languages, English, French, Portuguese, these are the languages that were brought by the colonial masters. But today, instead of us looking at our knowledge systems to say that, for example, South Africa has 11 official languages. English is only 200 years old. But if you look at the Zulu, Xhosa, Tswana, those have more than years of really. Now, if we begin to question a lot of things as to how are we going to speak all these different languages, look at this moment when the law is being used, white people brave only white lawyers. If we need to have power as the black people, if the Xhosas themselves only brave their own, Xhosa lawyers, because they understand the language, understand the culture. You understand the whole that you are also shifting the economic trend also in terms of that. Well, let me know when my time is up. Now, this is just a typical example how they've really downgraded and believe in our own system so that we can no longer rely on our system because the meant to do that is claims of racism, exclusions, and that. But are you saying the use of English as an official language that is entrenched by the legal system, is it not exclusionary as it stands, as it is? The fact that it's quite expensive to travel amongst the African countries themselves, but it's cheaper to travel to Europe. The fact that the laws that we actually use do not necessarily strengthen our knowledge systems. How do we argue for restoration and integrations of our indigenous knowledge systems alongside these mainstream systems? How our leaders actually, if you look at even the holidays themselves, those holidays that Africa celebrates, each and every country, they mirror more to the colonial history than the actual indigenous knowledge systems that we actually have Africa has not really been able to tap into. Moving into, if you look at the countries that uses their own systems, their own governance system, how they are thriving, how they actually in the end only translate this to English in order to import to other languages. Why can't we really, as Africans, as lawyers and healthcare systems, culture and all of that, mirror kind of really what is actually been happening, that we need to promote our own indigenous knowledge systems. We need to rely on the indigenous knowledge system because it holds the key to our sustainability and to our existence. Why is Africa continue to hurt herself in the absence of colonial bonds and chains? How can really these things be done? Because we have not really understood the impact of the law, how we can actually codify our own laws. Whether they are 43, they are all of that. This is the only way for us to understand that we live in diversity, in an inclusive society where everyone feels to belong to this society. Everyone feels that they also part and parcel of the governance systems. But until we do that, independence is just going to be whole and empty without any of us controlling, having the power on ourselves. The laws that we have will continue to mimic. Even the new laws that we do still have an exclusionary in terms of our own governance systems as the Black people. We really need to ensure that we develop and entrench our indigenous knowledge systems and ensure sustainable usage of these systems and reliance of them. You must always remember that you cannot separate the law, the culture, and the language, because this is one and the same thing in terms of an African context. And in that regard, I think I will stop here and really, I think I'll stop here. Thank you very much.
Thank you, Prof. One can ask a question: how do we avoid subordinating our customary law to Eurocentric legal paradigms? After listening to Professor Msinyane's presentation, I will call upon the next panelist, Noka Kajumba from Congress of Traditional Leaders of South Africa. A round of applause. Welcome.
Thank you so much, Sister. First of all, I would like to rectify something here about who I am. I am Nkosi Nokaka Jumba. I am not apologetic by saying Nkosi, leaving Kazi aside, because the responsibility that I'm holding in the office of chieftainship is masculine. I know that for sure. So there's no excuse. Even if men are fighting out there in the midnight, they wake me up to go and intervene, as I am the chief of that area. And they are the ones who decided that they call me that, as I am the first female traditional leader in the area. So I felt I have to rectify that. According to the program was designed such that Umore Nakwadi be the one who is making the presentation on the aforesaid topic. Then after the leadership has decided, having noticed the challenges that Hosikwati has with attending the colloquium, the chairperson of the province, Ngosi Nongonyane, thought he will be the one who's going to do the presentation. But just because I'm here, as the former national chairperson of Contralesa Women's Wing, I can't be silent and pretend as if there is no one, if there is me. I'm here as the leader of the organization. Then I will be doing the least that I can do. The topic that we are given to talk on is the codification, the codified legal framework and its contribution to the dynamic nature of customary law regulating the institution of traditional leadership. The customary law is essential mostly in the rural communities, And when we talk of the rural communities, we talk about the communities who differ from each other because of the traditions and customs that they practice. So the community, the people in the communal areas are the one who designs their customary laws or their way of doing things, their tradition and such. So the codified legal framework has a huge contribution to the nature of the customary law. It can be positive, it can be negative sometimes. Its negativity only appears when the legal framework is being used in silo or without being in contact with the customary law. I will make an example whereby apho zibonisa khona uba xa bezinosetyenziswa zombini ngendlela elinganayo bezingayenza ibe bhetele njani impilo yabantu basemakhaya. Ndikhetha usebenzisa olulwimi ngoba ndiyazibona into yobana kolu lwasemzini wami isingesi ndisikhumsha kakuhle xa ndinomsindo. Ngoku with this topic andinamsindo and kufuneka ndicacise kakuhle nawundixolela. Let me use esisiXhosa. Into eyenzekayo kulomthetho wasesilungwini xa udibanisa nowesintu xa zisebenza ngokuqaqelana zinezinto ezingaziqapheliyo ezinokwazi ukusombululeka. Okokuqala thina kwi-customary law sifocusa kakhulu kwi-restorative justice, i-welfare yabantu, ukukhuthazwa kobuntu, that is humanity is our basic. So now with the coded legal framework, you find in our communities now having child-headed families which are legislated, which are there according to the law that is in practice in terms of legal framework. And according to the customary law, there is no orphan in the African culture. Because whatever we are doing, we are doing it looking at the wellness, making sure that in our areas there's always peace and stability. That's what we are looking at. Now you're going to the legal framework that is working in our systems now. You find an offender for the offense that he has committed in the rural communities. He's taken to the corrections. When they arrive in the corrections, there are the services that they are being given there, like a right to education, a right to be capacitated so that when they come out, they become better people. Then there is nothing that is talking to the victim on the ground. And no matter what judgment that might come out of the legal framework, it does not necessarily look into the wellness, into the well-being of the victim. And yet, if you go to the customary law and our way of doing things as the traditional leadership institution, we ensure, in fact, we always strive to have both parties being satisfied. Oh, thank you so much. Okay, thank you so much. I will note your time. So that's the difference that we have with the coded legal framework. That as it may, as the organization of Contra-Lesser, we still believe that we do need an opportunity or that the customary law be written down these days. Ngoba asisenayo ijonglizo college ebikwazi ukusiqeqeshela abantwana ukuze bakwazi ba ready for the position. And amakhaya amaninzi awanabo abazali abakwazi into yobana batransfere the information, the knowledge to them. Ngoku ufumanisa abantwana bayabhideka, the custom, the culture bayibone somewhere else, they think it's the best one. So if we might have a institution engakwazi ukusincedisa, for us to have it coded, we need to understand what is it that we needed to be coded. If we would think of coding the customary law. Let me thank the audience for giving me the opportunity. Thank you so much.
Thank you, Nkosi Nokaka Juba. I hope I got it right. Okay, Ndoribuwa. Where I grew up, you hardly find child-headed households because members of community, they step in and take care of the children. And it's a taboo to call someone an orphan because we've got mothers in the community who are there to take care of those who don't have parents. So you don't go around saying, that one is an orphan. We don't say that where I come from. Thank you very much, Nkosi. Now we're going to move on to the theme, the effect of constitutionalism on customary law. I will start with Bogudani Chikota Masiare. His topic is In the Name of Manhood, Reconciling Culture and Queer Rights in Ululwako through Ubuntu and Decoloniality. Ulwaluko. I don't know where he got it because Nimuvenda. Mukaya Wam is confusing me. Mukaya, it's time for you to come and address us.
Thank you very much. Good afternoon, everyone, judges, academics, traditional leaders, all protocol observed. Initially, I was going to come here and cite some few Xhosa clan names from my wife's side. But since I have a Venda relative here, I'm sorted. She even kneeled in front of everyone, so thank you very much. Okay, my presentation was 28 slides long, but I will try and be very quick. So the topic is In the Name of Manhood, Reconciling Culture and Queer Rights in Ulwaluko through Ubuntu and Decoloniality. So why is this important? So Ulwaluko, firstly, it is sourced as a right from the Constitution, a right to culture. However, there is a potential conflict with other rights. And the method that I will be proposing is that there must be a balancing of these competing rights using Ubuntu and decoloniality, and that this custom must align with constitutional principles. So Ulwaluko is central to the Xhosa culture, Xhosa identity, and women. However, and manhood, sorry. However, at stake, we have cultural survival and constitutional equality. So what is Ulwaluko? Ulwaluko is the Xhosa traditional circumcision. It is an initiation rite where you have circumcision and various cultural teachings that are taught, which are meant to transition a boy into manhood. So the significance of this is that it resembles cultural identity, belonging to community and spirituality. So it is done in 4 stages. However, other sources have summarized this into 3 stages, which includes pre-initiation stage, where there are preparations and they're preparing the initiate, where they are appointing the person who will be guarding the initiate at the school, and so on. And then there is also the circumcision phase, which involves the cutting, and then there's also the seclusion stage, which involves the phase where the initiate, after performing all these things, has to isolate himself. So the problem, however, is that what we have seen is that Ulwaluko often reproduces a hegemonic masculinity. So hegemonic masculinity is this dominant masculinity that a man must be heterosexual, a man must be dominant, a man must be in control, a man must be in charge. So as I had said, this is a constitutional right. It is sourced from section 30 and 31 of the Constitution as a right to culture and to belong to a cultural community. So this actually relates to the notion that culture is recognized as fundamental to identity and dignity. However, Section 31 of the same constitution, which guarantees this right, also states that this right must be practiced in conformity with other rights in the Bill of Rights. In the international stage, international human rights law also, international law also protects this right. Article 27 of the Universal Declaration of Human Rights protects the right to culture as a right to take part in cultural life. And Article 15 of the International Covenant on Economic, Social, and Cultural Rights also offers the same protection. However, same in international law, the protection of culture is not absolute. It must not violate dignity, equality, and non-discrimination. So, where are the limits of Ulwaluko? So this is based on an article that was written by Ntozini and Ngangweni, which is called Gay Xhosa Men's Experience in Ulwaluko. That is a 2016 article where he had these face-to-face interviews with Xhosa men, Xhosa gay men who have undergone Ulwaluko. And some of the things that people, these initiates were saying is that during Ulwaluko, they were isolated, they were ridiculed, and they found it difficult to learn the isiXhosa language because it is heterosexual and demands that they move in the heteronormativity. Lastly, what was then also apparent is that most of these people that were interviewed afterwards, they sought counseling, which then has to show us the type of treatment that they received during Ulwaluko. So what we have then seen is that Ulwaluko then currently, as it is framed, it potentially violates Section 9 of the Constitution, which is equality, Section 10 of the Constitution, which is dignity, and freedom and security of a person, which is in Section 12. So as I continue, as it stands, customary law, so in 2021, based on most of the things that were happening in initiation schools, where children were dying, there were a lot of bogus traditional initiation schools and so on. There was the introduction of the Customary Initiation Act. However, if you go online and you check cases that have come under this Initiation Act, I found only one, which was in Limpopo, which was a member of the Executive Council for Cooperative Governance, Human Settlement and Traditional Affairs, Limpopo Province versus Motapo, also referred as Muncha. In this case, the court had to determine whether the case that they had received or the school that they had, sorry, I was distracted by the timekeeper. So the court was asked whether an initiation school was illegal under the Customary Initiation Act, and then it found that the school was indeed illegal. However, it did not shut it down because of it said the initiates also have a right to this culture. However, the critique then is, are there no other registered or legal schools around? Which then shows us this importance. So there is also a role of masculinities. So masculinity is not biological, it is a social construct that shapes how society defines a man. There are multiple masculinities. There's hegemonic masculinity, which I referred to, which is this dominant idea that a man must be strong, a man must be heterosexual, and so on. Then there's subordinate, which is this idea that if you do not conform to this dominant masculinity, then you are not man enough. Then there is also a protest, which then these queer people would fall under, which says that if you do not resemble our the values and traits of heterosexual men, then it means that you are against us. You are protesting against what we know and understand as manhood. So in South Africa, colonization and apartheid entrenched this hegemonic masculinity, where men are expected to be heterosexual, dominant, powerful, and in control. So it is the same with Ulwaluko. The Xhosa initiation rite is meant to transition boys into men. The initiation process does more than the circumcision. It teaches cultural lessons about manhood. Currently, these teachings reproduce hegemonic masculinity, portraying a real man as heterosexual, which means that queer men are excluded or abused, possessive and powerful, dominant over women and other men. As I continue, in an article by Tapiwa Magondo, Michelle Glenda, and Kyle Jackson, titled The Role of Xhosa Traditional Circumcision in Constructing Masculinity, they argue that Ulaluko constructs hegemonic masculinity by promoting dominance, heterosexuality, and authority, which marginalizes alternative masculinities, especially queer ones. So in all this balancing, as we have already determined that there is obviously a potential conflict with the Constitution, which is the Supreme Court of, which is the supreme law, we can already determine that Section 36 is not applicable here because this is not a law of general limitation. So we will have to deal with this in terms of pepuda. We'll determine whether there was discrimination and all those factors listed down. But there is this important principle that even international law has gained prominence, which is about balancing of competing rights. The principle is clear: the all rights are not absolute, they must be balanced. And the court's approach will be, they will weigh culture versus equality or dignity. With cases like the S versus Makwanyane case places more favor on the latter, which is equality and dignity. Even going as far as stating that where you have a right, a single right that potentially violates several rights, then there is definitely a cause for that right to be limited. So as we borrow from case law, in the Christian Education South Africa case, Christian Education South Africa versus Minister of Education in 2000. This case, the issue here was whether a ban on corporal punishment in schools violated religious rights and cultural rights. The court's approach was that it balanced the religious freedom and cultural rights against the rights to dignity, equality, and freedom, and security of learners. The outcome was that the Constitutional Court upheld the ban, holding that even religious practices must comply with the Constitution. So the argument here is that there is a need to then, before anything else, to decolonize masculinities and to decolonize culture. As I had said, that there were so many distortions and imposition of foreign ideas and values in masculinity in terms of how we see men and so on. So as we might be aware, South Africa was founded based on three foundations, which is the racial ontology of conquest, this idea that black people are not human enough, the racial epistemology of conquest, this idea that since they are not human enough, then the knowledge they produce is not sufficient, then also the racial capitalism, the idea that since these people are not human enough, not well educated, then they cannot preside over their means of production, they cannot enter these fancy professional jobs and so on. So the persistence, I'm sure from the conversation that I've had here, there is no need for me to emphasize that the colonial legacies persist even in today's generation. For example, we are all aware that this constitution is very much unjust, an African and a colonial tool. Secondly, the Fees Must Fall protest was a clear reminder that we are still living in a time where education is still deeply entrenched in Eurocentric knowledges. So, however, there is this part about constitutional abolitionism, which I am one of them. So it might be shocking why I'm saying that the Constitution can offer a bit of assistance. So, but it will become clear as I quote how Professor Madlingozi defines decolonization. So constitutional abolitionists say the Constitution cannot deliver justice for black people. The Constitution was not for black people. The Constitution is merely a continuation of all the other constitutions that founded South Africa. However, we have to ask our question I liked what Nkosi was saying here to say, how do we balance in terms of reality and so on? So in reality, is the Constitution therefore a document to be discarded? Do we just throw it away as a useless document? No. There are values that can be taken from the Constitution. Even though the Constitution does not explicitly recognize Ubuntu, which the interim Constitution did, the Constitution has several values which align with Ubuntu, and those are the ones that I'm borrowing from. So for us, decolonization today is undoing the injustices of the past, rewriting the history, culture, and knowledge of African people from their own perspective. Professor Mbembe argues that freedom in South Africa hasn't dismantled the core of racial domination. Then Professor Madlingozi argues that decolonization is simply the fostering of critical mindset with a hope of fundamentally changing society. That is where, as a constitutional abolitionist, I'm moving with that discussion to say we have been talking about decolonization at high level. How do we relate decolonization in a sense that it's going to materialize and have material changes for the people on the ground? So as I go closer to closing, so decolonization is not a return to the past, and I must emphasize on that. Decolonization is not merely an uncritical return to the past, because there is clear evidence that in the past, not all was perfect. For example, we had hierarchies in the past. In Africa, in pre-colonial Zimbabwe, women were excluded from land ownership, though they could invest in livestock. In Urundi, Rwanda, now known as Rwanda and Burundi, society was deeply patriarchal. Women were treated as property exchanged between men, virginity was highly controlled, and child marriages were common. So instead, for us, decolonization is about reimagining masculinity and culture in a plural and evolving sense. So it would mean the adoption of living customary law to make Ulaluko responsive to today's realities. If we are saying that we need culture and that culture does not represent us, then living customary law is the one that, if adopted, as many speakers have said, that it is based on the community's perspectives, it is based on the community's needs, realities, and so on. So as I close, so living customary law in practice, what would it mean? It would mean that culture is not static. It must evolve with society and the constitution. Living customary law allows adaptation without abolishing Ulaluko. As I heard that there were calls that this custom must be abolished. That's not the argument. The argument is that the harmful part can be removed without losing the main aim of Ulaluko, which is the right of passage. So the key takeaway here is that a reimagined practice of Ulaluko is possible, a practice that affirms both cultural heritage and also advances the constitutional principles. Thank you.
It's nice when the chair is Yomkaya, you get extra time. You know, I've been all alone for many years, so today is my day. You are here. And this brings me to the question, how can we better balance tradition or custom with the constitutional values of equality and dignity? I'm always fascinated here when I see colleagues and friends excited about preparing their boys to go to initiation school. They talk about it, and I'm like, where I come from, this is specifically reserved for the fathers or the male in the family. Mothers don't take part in these discussions. And I even said to my daughter when she was talking about this and that, I said, where did you hear that from? We are not allowed to talk about these things. You're not supposed to. In the Chivenda culture, mothers or women are not allowed to talk about initiation and all that. It's specifically reserved for males or for the fathers. Thank you, Bochkota, for such an interesting presentation. The next speaker is, the next panelist is Ms. Asanda Mbolambi, my colleague from the Faculty of Law. She's going to talk to us about exploring the viability of lobola as an option for addressing inheritance rights of posthumously and artificially procreated children. Madam?
Good afternoon, everyone. All right. Let me start my presentation by posing a question to the audience. Of course, I do not expect you to answer the question, but the question is, do you have a will? Do you have a will? If you do have a will, does your will accommodate posthumously and artificially procreated children? If I said I do not want answers, okay, please keep that in mind. Okay, there are two of us. I think Advocate Seth is sitting at the back. Be that as it may, our topic is about exploring the viability of lobola as an option for addressing inheritance rights of posthumously and artificially created children. And our presentation is outlined as follows. We'll deal with the introduction that unpacks how posthumous and artificial child is created. And then we will also look at the legal framework and examine the requirements that must be met in order for one to inherit. And we'll also delve into the principle or into a principle of Nascitara's fiction and whether it accommodates posthumously and artificially created children, and also the will, if you have one, whether it accommodates them, and also the Wills Act. And we'll also examine the recognition of traditional African processes as solutions to contemporary legal problems and see how the traditional African processes can be utilized to address the challenge that we currently have. And we'll also examine the institution of lobola and see how lobola can be used as a viable option to accommodate posthumously and artificially created children. And then we will also look at lobola and the challenges of posthumously procreated children, and then we'll conclude and determine whether lobola can be used as a viable option in instances whereby you have a child that has been posthumously and artificially created, and then we'll conclude. Okay. Now, advancement in science and medical technology have created scenarios that were imaginable from a legal perspective just a few decades ago. In particular, developments in cryogenetics and cryopreservation, which involve the freezing and thawing of embryos, effectively enable a deferral in vitro fertilization, officially known as IVF. And then this particular process allows for the preservation of embryos for utilization in future IVF cycles. And notable, it is even possible to extract nowadays, because of this technology, to extract and freeze both semen and, more recently, even female eggs. They can be frozen. From whose body? Even from the body of the deceased individual. That is possible in terms of the technology that we currently have in South Africa. And when a cryopreserved embryo is utilized after the death of a parent, the subsequent implantation in a woman's womb via IVF results in the birth of a child conceived posthumously and artificially. So that is how they are created. So that was just a brief background. Now, let me pick a brain and give you guys this nice example so that you can have at least an idea of what we are trying to do with my colleague. I'm going to read this example. If A and B, a young couple in their early 30s and university employees, agree to defer the idea of having children until they reach a certain rank. And in academia, in order for you to know that you are the guy, you must reach the status of a professorship. Okay, so if these two couple, they agree that they will wait until they reach the rank of professorship. After 10 years later, they agree that their gametes will be extracted, but cryopreserved with the intention of later fertilization through the use of IVF and surrogacy. Now, what happens? A year later, A dies in a car accident, and he dies intestate without leaving a will, leaving behind an estate to the value of 2 million rands. Remember about the agreement that they had earlier on. B decides to honor the agreement she had with A by ensuring that their 2 children, that is C and B, are posthumously procreated through IVF. Now, this particular scenario, then it gives rise to important legal questions regarding the inheritance of DNA since they are conceived posthumously and artificially created. Now the question is whether DNA are eligible to inherit from the estate of A. Remember, A died without a will. Keep that in mind, and please listen attentively. Now let's look at the legal framework, and the first thing that I'm going to do is to touch on the requirements to inherit. We are all aware of the fact that there are plenty of the requirements, with the exception, of course, that must be fulfilled before the role of succession can come into operation, but I'm going to highlight only 2. The first one is the deceased must have died, and the beneficiaries must have been alive or must have been conceived at the time of delectio. But in this case, these children, C and D, are not even yet conceived. The sperms and the eggs are frozen and kept somewhere in a laboratory. So, but in terms of our law of succession is that there are certain requirements that should be met before one can inherit. Do they meet these requirements? The answer to that is no. Now let's move on to Nascitara's fiction, that is our common law, all right? And see whether it accommodates posthumously and artificially created children, all right? Now, South African law, under the influence of its Roman and Roman Dutch law heritage, recognizes that an unborn child, normally referred as nascitaras, and we all know that this is a Latin term, is incapable of inheriting. And what are the requirements when one wants to apply this particular legal principle, that is nascitara's fiction? It is interpreted in this following manner. 1, the child must have been conceived at the time of the devolution of the benefit. 2, the inheritance has to be to the advantage of the unborn child, and the child has to be subsequently born alive. Let's go back to our question. C and D. Sperm and eggs are frozen somewhere. They have not yet even been conceived. Now the key question is, does the common law principle of Nascitara's fiction apply? In the case of a posthumously procreated children, it falls short of meeting the requirements of Nascitara's fiction in that the child is neither born nor conceived at the time of the dissolution of the benefit. So this principle of common law does not even help us. Are you still with me? Okay, now let's forget about common law and have a quick look on the testate succession, in particular the Wills Act. And in the case of testate succession, the Wills Act clearly provides for inheritance by posthumously created children. Such a child will be eligible for a share as indicated in the will. Now this takes us back to the question that I had initially posed earlier on to say, do we have a will? Most of you indicated and said yes, and then the follow-up question was that, are those children that is posthumously and artificially created children accommodated in your will? So what is important in terms of testate succession is that there should be a clear indication on how they are going to inherit. But the problem arises in situation where a will merely refers to unnamed children or issue. And the situation is compounded by Section 2D, 1C of the Wills Act, which provides as follows. Any benefit allocated to the children of a person or to the members of a class of persons mentioned in the will shall invest in the children of a person, or those members of the class of persons who are alive at the time of the devolution of the benefit, or who have been conceived at that time and who are later born alive. So what this particular provision does, it codifies the principle of Naskidara's fiction. Does it address the question that I had initially posed earlier on? No, it doesn't. Now, the Naskidara's fiction, which recognizes that an unborn child is capable of inheriting, requires that the child must have been born alive or must have been conceived. Similarly, Section 2D1C of the Wills Act accords the right to inherit only to beneficiaries who are alive at the time of the devolution of the benefit or who have already been conceived. Now, clearly, posthumously and artificially procreated children do not meet one of the prescribed requirements, in that as beneficiaries, they are not alive or they have not yet been conceived at the time of delectio. Now that I have dealt with, I would say, with three legal framework, the requirements, principle of Naskidara's fiction, and the will, it is pretty obvious that none of these legal framework accommodate these children. Okay, moving right along, let's look at the recognition of traditional African processes as solution to contemporary legal problems. Customary law has always been flexible, adaptive, evolving, and pragmatic in terms of its approach when responding to societal problems. And we have Bennett who articulated and said, in contrast, common law was always flexible and pragmatic. Strict adherence to ritual formula was never absolutely essential in close kit. Rural communities where certainty was neither necessity nor a value. So, for instance, the ceremony to celebrate a man's second marriage would normally be simplified. Similarly, the wedding might be abbreviated by a reason of poverty or the need to expedite matters. And now let me jump quickly, without wasting time, and go to the case of S versus Magwanyana. What happened in the case of Magwanyana? Because in South Africa there was capital punishment. They had to go back to traditional African processes to try and resolve this particular matter. And this is what they did, or this is what the court held in the case of S versus Magwanyana. The court relied on the principle of Ubuntu to abolish capital punishment in South Africa. Why can't we use the lobola to make sure that these children are also accommodated so that at the end of the day they can also inherit? And we also have the case of Maluleke that I'm not going to deal with, but there are a number of cases that we have cited with my learned colleague. Now let me go straight to the institution of ilobola and see how a lobola can be used as an option for addressing inheritance rights to posthumously and artificially procreated children. The institution of lobola, generally there's no consensus on the meaning and the function of lobola. However, according to Oliver, open quote, it is probably impossible and unwise to give a narrow description of the institution of ilobola. And we also have one of the scholars, that is Usibisi, and according to him, he highlights three broad functions of lobola, and one of those is legal functions, and the second one is social functions, and the third one is economic functions. And the shortcoming of the current legal framework in accommodating the right to inherit of posthumously procreated children emanate from these factors. One, the law is time-bound, meaning that the beneficiary must have been born at the date of delectio. Number two, it is orientated around the individuals. It is about the deceased, not the surviving spouse or child of family. And lastly, it is rigid. It is about upholding the old principles and doctrines However, on the other hand, the viability of customary law or lobola as a solution lies in the fact that it is opposite. And our view with my colleague is that in terms of customary law rules, posthumously procreated children may be eligible to inherit as long as the lobola has been paid. The reason being that the primary function of lobola is to identify the identity of children. That is very important because as soon as the delegates were sent, lobola was paid, all the traditions and processes were followed, and then these two couples, at the end of the day, are married. As soon as that child is being born, he or she knows his or her identity, and that is not in dispute. One of the primary purposes of lobola, as I've already indicated, it is to establish the identity of children. The function of lobola seems to be widely accepted in case law and academic circles, even though there is generally no consensus on the functions of lobola. Again, I'm going to go back to one of the scholars, that is Oliver, and Oliver states that lobola plays many functions, but chief among those functions is that establishing the identity of children. All right, let me go straight to the quotation. Oliver states that it serves to, that is lobola, that is its function, or amongst its many functions. It serves to legitimate the children born of a woman. It is clear, however, that the primary function of lobola is to transfer the reproductive capacity of women to the family of her husband. In other words, there is a direct correlation between A, the transfer of lobola, and 2, the reproductive potential of women. I'm about to finish, please bear with me. Lobola and challenges of posthumously procreated children. Sibiso also makes the following important remarks relating to the use of lobola for the soul to the transfer of transferring the child from the maternal family to the paternal family. He says, it is possible for the father of the child to pay lobola for the sole purpose of transferring his child from the maternal family to the paternal family. And this happens where the relationship between the mother and the father has ended. So it's possible that the father of the child can pay lobola as much as they are no longer in a relationship. This seems to be common practice, though it may differ and be referred to in different names by different traditions. So in closing, Chair, I promise you this is my last slide. In conclusion, it is important to take note of the concern raised by Dalem and Zala about inheritance discrimination of posthumously procreated children in South Africa, and they've made these remarks. Colleagues, please bear with me, I'm about to finish. They've made the following remarks. There is thus a real danger of the emergence in South Africa. A group of second-class children denied inheritance. To deny posthumously procreated children is to place them in the same position occupied for centuries by so-called illegitimate children who were not permitted to inherit from their fathers and paternal relatives. Children have no control over how or when they are born, and therefore it is necessary to limit differentiation against them as much as possible. It is therefore important that innovative and pragmatic solutions be found to the challenges facing the right to inherit of posthumously and artificially procreated children. So me and my colleague were of the view that lobola promises to be a viable option for addressing inheritance rights of posthumously and artificially procreated children. However, it must be noted that it has its own limitations. Thank you so much, colleagues, for listening.
Golo. I don't know about you, but I've been schooled I'm a corporate lawyer, so to speak. All I know is to wind up companies, business rescue, protecting minority shareholders, declaring directors delinquent. So, yeah, this is interesting. Because what came to my mind quickly was like, is she talking about Section 21 of the Companies Act, wherein you enter into a contract on behalf of a company that is not yet in existence? But she's talking about something else. Thank you. So we're going to enter the Q&A session, wherein you ask questions to the panelists. I will ask for assistance with the mic. When you ask the question, please indicate who you are addressing it to. Remember, we've got Professor Msinyane online. You can also ask him a question. Thank you.
I'm Chief Dinwayo from Lusikisiki, Pondo Kingdom. As I'm sitting here, ndiyazibuza uba le Nasitaris fiction ingaba ithathe ibeke phi na isiko lethu lokungenwa. Sinesiko lokungenwa phaya emampondweni. But ke question yam ayikho apho. My question is directed to the panelists who were commenting about codification of customary law. I'm even not comfortable referring to it as a law, customary law. To me, it is a way of life or a way of doing things. It's not law as I know it. However, with the common law, at least we know that it is act so and so, of year so and so. We know when it was created. With the customary law, we don't even know when it was formulated. We just find it there as we grow up. Now I want to know if it's possible to have an amendment of this customary law or repeal it. Is it possible to repeal it or amend it? Thank you.
Thank you, Chief. We can take 3 or 4, then the panelists will answer.
Thank you, Ms. Program Director. I've got 3 questions. I will start with Dr. Wilson and come to the Professor or Doctor on the
Professor Msinyane.
Yes, online, and then come to the issue of the children. On the issue of codification, Dr. Wilson spoke about having difficulty in ensuring that, or saying that it would be difficult to codify the laws or the customary law because of our diversity and because of the fact that we practice different cultures. I do admit that. I concur, but my problem is that, do we believe that it cannot be codified because of those differences, of that diversity? Because you go to that specific kingdom, I want to mention kingdoms now. We've got Amabata, we've got Amampondo, and then you sit with them. You get to know exactly what they are doing and how they are doing those things. If we take that approach, can it not still be possible to codify those customary laws? I'm specific to say this, and the problem is that our children that are growing are getting a third, if not fourth-hand information, because all the people that have known or that knew what used to be done are dying. So bazawuze bathini aba bazalwayo, because it's even worse now that we are putting them into these model C schools. They are literally dwindling. Iyaphela customary law at all. Can we not make it means that we codify as per kingdom? And anphendule apho. Then getting to the issue of just 1 minute. I wrote these notes. Okay, before I go to the online, you spoke about masculinity, this and that. I can't quote him verbatim on the issue of ulwaluko. Hey, it is not. It's not something that I want to dwell much on. But do we really believe that the issue of masculinity versus cure? Let me make a disclaimer. I say this to everyone. I've got a big problem. I still need to be converted in Shunyayezo and Gutuge. Le issue yobana uthi uyintombazana ngidibana usopitswa zibhlukwe uwalka ngathi uyinto uyimfana ndine problem ndicela ukuba ndizichaze. Le issue yobana uyintombazana ufana ba untsontso uhleli phansi ndidibane nawe ngoku sofuna ulala nenye intombazana nengxaki ndicela uba ndizichaze. Ngoku ndithi ke ngoxa ndithetha ngoku ndithathe ndise phayela lukweni ndiqonda bana if sithetha ngento bana is masculinity inoba aba ke ngoku begqibele izipisa ngebhlukwe efana name lipstick xa ke fika phayithini, because ke they deny their masculinity, how they are dealt with phaya. Mhlambe ke nizawuyithetha kwenye platform ningafuna usixelela thina, but I'm thinking of the parents who had to accept the fact that abantwana they were born boys, then all of a sudden because of whatever, tina in my Christianity sitting on my demon about chinchile, I'm being truthful. So what then happens? That's another question. But tina abantwana babantu. Now the last okanye the abantwana. We have a big problem on the issue of children. I've got a womb. My womb carries a male seed. And when I talk of my children, I talk of my children as the identity of the seed that I carried. But isiXhosa again, they are very related. Why I'm saying so is because endimithiswe kwaKhambule because ndingakhange nditshate makabe ngwalapha kwaNozulu. So isiXhosa sona siyazalana nongamnanyani. Athi umntana weseed omithwe phaya kuthiwa mayengube ngwaphaya. So iyagqwetha isiXhosa sona isintu siyathanda ugqwetha. Now kokukugqwetha ke ngoku kuhamba kube ne problem because I'm widowed. My husband passed on in 2014, but a child that I will give birth to in 2020 kuzawuthiwa ngonyama. Fully knowing into ukuba ngonyama ulele namaqanda akhe pha engcwabeni. Now that's why I'm saying ubuntu isiXhosa nobuxoki are very related. If now we are talking of inheritance, aba bantwana lo zele ngo-2018, must that child also inherit from ungonyama because he's using that surname? Those are the dynamics that we are experiencing, and they are very challenging. How do we address those things? Hence, earlier on I said, can we be comfortable to talk about these uncomfortable issues? Because they are distorting the whole culture, whether the culture was truthful or not. But because of the times we are living in, I'm challenging this. Umntana wakwamafunda makahamba ayokwangamafunda ayo-inherita pha owakwangonyama inherite kwangonyama. If I can mistake ngenzeka kuthiwa I'm pregnant in 2020, ndingambiza ifani yalo tata mna ndixaba nabantu basemzini because ndidikwe into yobana at some point they get to be ukulandwa because of the challenges kuthiwa ingowalapha. Because nabo ngoku bayafuna into okubana bavakale kwakwade besuffocatwa kudala kuthiwa no thula. They are no longer keeping quiet at this day and age. What then do we do if we talk about lobola and everything and anything else that has got to do with aba bantwana?
Yes, should give someone a chance and then you can respond.
Thank you. I have two questions to different speakers, to different speakers. The first speaker is Dr. Karen. Apparently, you have a problem, as I do, with the codification, because in my view, that will going to inhibit the dynamism of the culture or customary law and rendering it equal to official law. Now, how should we go about in avoiding that? Could consolidation not be an appropriate way of solving the problem rather than codification? That's the question. The question to Mr., I don't know the pronunciation will be correct, Shikota. Huh? Shikota. Shikota is talking about the Constitution not approving the initiation in some instances because there are those males who are said to be gay and so on. But now, my problem, the first question to him is whether the parents who want to prepare their children for manhood should not do that. If they do, how are they going to extricate those who are in the middle line, so to speak? Thank you.
Thank you.
Okay. Thank you so much, Chair. I think the first question that was directed to us is related to the custom of ukungena, if I'm not mistaken. Our argument is that the purpose, or sorry, one of the functions of customary law is to establish the identity of children who will be born out of that. In other words, you identify children who are born out of the relationship or marriage by way of lobola, which goes back to the point that was highlighted, meaning that as long as you're still married, the kids or the children that are going to come out of that, even if your husband passed on, then they will remain the children of the family where you are married. That's our understanding of one of the functions of lobola. My understanding of the custom of ukungena was that the intention is to ensure that even after the husband has passed on, the children will still be coming from that same family, because the brother is going to be the one who will be, you correct me if I'm wrong. 2 points there is that it's in line with our argument. Then the second point is that if we can check into the aim of that custom, if it was to maintain the children or the family lineage, maybe now it's time to ask a question if what we presented cannot serve that same purpose. In other words, instead of now, it's even much more better, instead of the children who are going to come out of the marriage after the death of the husband, instead of them coming from the brother, it's possible that they can still be that of the spouse, despite the fact that he passed on a number of years ago, because they will be cryopreserved. that is the gametes from both parties, and then the wife at a convenient time can then do IVF, and then those children can remain. So that would be my contribution in relation to the custom of ukungena. Maybe it's high time that we check it, that given the fact that customary law in its very nature, it's dynamic, it's flexible, it's responsive, it would not in any event not consider science as well as technological advancement. So isn't high time maybe that we check that custom and see if it cannot be addressed, those intention or objectives that it intended to achieve cannot be achieved now by use of technology as well as medical advancement. Then the second question, I'm sorry, that may not be providing an answer, but just posing more questions instead. What was the second question that was directed to us? It was only that one. Okay.
Thank you, Advocate Sethi. Dr. Karer.
I'll address the first question posed by the chief. And you made a very interesting remark that customary is the way of living, like the tradition that you have observed, the things you do. Maybe if it's a marriage ceremony, somebody is telling you whatever you're doing is illegal simply because it's outlawed by a codified way of you've been put in a corner such that this is what you conform to. Again, you've compared the issue of the statute being repealed. So, and the question, and this partly answers her second question, where do we find the customary? The greatest challenge we have is that the kind of customs, they are not documented. I think we have a challenge. Look at, for those who listen to classical music, we have even letters written by Mozart to his father, and that was done in 1600. We do not have the equivalent, of like now to jump to her issue in terms of really our kids. They are enjoying fourth-hand information simply because we have not documented what we hold. For instance, what can I say about my traditions? We go to ceremonies, yet these things are not clear. And it's a challenge, it's a clarion call for everyone. If you have been passed that information, why don't you document it for, for the other generation to have at least first-hand information? And then to answer her question in a more detailed, in terms of when I mentioned that the codification is a challenge, but it's also an opportunity in terms of really going back, and this will also touch on Justice Madondo's question, is we are so deep into this whole concept of common law. We are so deep, we are in the deep end. So how can we undo it? I think it would call for a revolution, because let me quote a theory, path dependence, is that the moment you take incremental steps, we have taken very many incremental steps to get to where we are, partly contributed to a myriad of factors such as colonization and so on and so forth. So for us to undo all that would require something more than a revolution, to be able to go back to where we were, assuming that was the starting point, where we want to be with our generation. Say, custom is recognized as hierarchical, because as you looked at even the different constitutions, even ours, customary law has been relegated. It's not featuring. In terms of the food chain, it's down there. You can do all you want, conform to the Western style, human rights perception as they see it, But where is our customary law? Where does it sit? How did we get there? So if we can be able to unpack that, it will be beneficial for us to now go back to the starting point where we can say customary law is gaining traction.
Okay, thank you. So I had two questions. I'm going to have a difficult time responding to the first question because I felt that the delivery was not that respectful for the audience, especially considering that there might be core people in the house. So for me to stand and say, I do not understand this, I think as for an academic space, it was not a good thing to say. But, so who I choose to be attracted to does not take away the fact that I am still a man. So I think that's where the biggest challenge is, because both questions relate to that. These people are attracted to other men, but they are still Xhosa men. They still want to pass the rite of passage, but it does not allow them because it is framed in a way that does not recognize that reality. That in contemporary South Africa, there are people who are attracted to other people, which is actually no one's business. Who someone is attracted to is not anyone's business. And then in the second question, so I think we are treating gay people as people with an illness. This is not an illness where you say, but what will happen to other people who will come to Ulaluk and find those people there? What's happening to us? There are gay people here. What's happening to us? Nothing. And remember that these are also people who subscribe to customary law. And we are sitting here, we are saying we want customary law to be at the standard of the Constitution. How are we going to do that when we are in the same customary law? We are saying no, but we don't want these people. But these are Xhosa people who are in the community, whose lived realities and experiences is the one that is going to contribute to the knowledge of customary law in the years to come. So yeah, I think I've answered the question. And then also in terms of lesbians, so that's why I'm saying that I think there's a misunderstanding. A lesbian, why would a lesbian want to go to a male traditional circumcision school? Because she does not have a penis. What would happen is that the same scenario will apply to lesbians if they want to go to the women circumcisions, because they are there. But what would happen when that woman goes there and she's now treated as if she's not human enough? So I think that's something that we need to keep in mind and just think about that. To say it's not about who this person is attracted to, how they wear, and so on. Thank you.
I think we can take 3 questions if we.
Greeting to the house at large. My name is Mposinterad. I'm second year LLB students at East London campus. I have one question for Ms. Kosi Nokaka Jumba. You mentioned that customary law should be written down, given that currently it is not written down. What are the processes that should be taken in order for customary law to be written down? Thank you.
Okay, thank you very much, Program Director. My name is Vuisa Pikashe. I'm also a second year law student at the University of Fort Hare in East London campus. Mine too is very short, is to just to understand what has been mentioned To you, Ngosi, I just kind of forgot the name right now. You've mentioned that the people who actually establishes the legislations as entrusted by the Constitution, do they have aspirations of customary law? So if then that's the case, what should be done? Because the same very Constitution is the one that indoctrinates the power to those people to establish the laws, which the preamble itself that a true elected representative, that this Constitution is the supreme law of the land. So meaningly that those provisions that are indoctrinated, giving power to the likes of the ministers to initiate the bill. So then if that's the case, to ask whether those people have the aspirations to establish, to acknowledge the customary law, then what should be done? And taking into account those powers enshrined in the Constitution. Thank you so much.
Good afternoon. Ndingunkosi Tyali from Amampondo Misasa Ntshonalanga Traditional Council. Ngapha uTsolo. My question is going to be directed to, I think, Ms. Mbolambi. I heard she was talking about lobola and this issue and the recognition of umntana uzalwe ngaphandle komtshato, of which there is ilobola which talks to the wife that is being married, and there is intlawulo which talks to the child that is born outside of a wedlock, of which we do recognize, ngokwe custom, that lamdana ngumntana lapha, even though because she's born of not the wife to the family, but of the other woman, opha kude. But when it comes to inheritance, that child does get inheritance. Lo mthetho ungumthetho okhoyo. Wanted to find the difference between the lobola and the intlawulo, because it's two different things. Yeah, thank you.
Greetings. My name is Temusho Malachi, and I am a final year LLB student. So my question is to Professor Tumi. He made mentions that we need to acknowledge and embrace our indigenous knowledge systems. My question to him is that how do we do that in a society that is heavily influenced by Western systems? How do we live and practice our indigenous knowledge in a system where Western knowledges and systems apply?
Thank you, Prof. Samsinyane. You can answer the question. Prof, can you hear
Subsection
me?
3 of the Constitution. Yes, I can hear you. Can you hear me?
Yes, yes.
Can you hear me? Yes. I'm saying, in answering the question, if you go to section 211, subsection 3 of the Constitution, it says the court must apply customary law when that law is applicable. That's number one. If you also look at section 30 and 31, talks about the rights to culture, and we read that together with section 9, with dignity, and then also equality. That should be the basis in which really that we need to start to say that when customary law is applicable, what we lack, most of us, because what we are taught at universities, what we do practice law, we do not necessarily, have to fight for the customary law to really be the law that governs. For example, when we talk about a will, the law that regulates the wills today was created in 1960 something and also 1987. Where were black people during that time? We did not have any participation role or development role in those laws. But today, when we die without a will, immediately lawyers and everyone that does, they run to this Interstate Successions Act. Maybe in that particular moment, the person who passed on left, some last wishes or the last words on a bed, while they were on a bed, which in my language we say, meaning that person on a deathbed when they are making the last wish and disposition to say, when I die, and this is prevalent in all African languages. Everyone can agree with me here. When I die, I want this house to be given to Sibusiso. When I pass, this cattle must be given to that. We understand the significance and the meaning of this idiom and the language because it's also the law on itself. But the minute that the members of that family disagreed, now they claim that there's no way. Whereas in terms of our customary law, that is actually a disposition of assets in terms of our customary law. So when you now go to court, you are not going to argue the interstate successions. You are going to say this law is not applicable. The law that's applicable is the customary law. And how do you dispose of your assets in terms of customary law? You say that this is how we dispose it. Last wishes were made, there were those who were present, and this is how these assets were given to members of the family. We do also know as African people that there are repercussions in terms of non-compliance of those wishes. So we need to really think out of the box as Black people in how we start to enforce and entrench our laws that are real, that are applied in our communities. This is just an example in which really how we can really start to document our laws, also fighting for them to be recognized by the court itself. Thank you.
Thank you, Prof. Nkosi.
Thank you very much for the question, but oh, okay. No, the only thing that needs to be done is to have the customary law being documented. Because one of the challenges that we face is because people are taking decisions on the issues that are affecting traditional communities without understanding the outcome of the decisions that we make. Like we may decide on something with regard to the rural communities, and yet afterwards we don't understand what will come out of that. I will refer you to the honor that I once had in 2008 when the judge of Mthatha High Court referred a case to me for my opinion. He found who was guilty, who was not. But the problem was with the sentencing on how to sentence them. Then he consulted with me for my opinion. I gave him my opinion. He followed it up, and the decision that he made was then fair because he looked into the issues that I made him look at according to the tradition of that area that I lead in. That's what I was referring to. Thank you.
Okay. Thank you so much for the question. In terms of the law in South Africa as it stands, it's not possible for, in fact, there's never been a case whereby a child who has been posthumously procreated ever benefited. Remember, take the example that Ms. Mbolambi gave earlier on of a child, the father who passed on now, and then the child will be cryopreserved, that is the gametes of the parties, of the spouses, and then IVF will be done 10 years later. According to the law as it currently stands, that child, especially in the case of intestate succession, that child is not going to inherit. As I indicated, we are not aware of a case that has ever been considered in South Africa. We know in other jurisdictions that there are instances whereby courts consider that. For instance, there is an Australian case where the child was the child was born a year after the father has passed on. But the difference there is that while the father was still alive, the cryopreservation was, that is the mixing of the gametes between the parties was done while the father was still alive. And then there was a cryopreservation, and then the child was born later after the father has died. So what the court did in Australia, they developed Naskitaras fiction and say, in that instance, it will apply because the fact that the germans of the parties were mixed before the death of the father, then that would be considered as if the child was conceived, which is basically what Naskedara's fiction requires, is that the child must have either been born or conceived as at the date of the death of one of the parties. But in South Africa, we've never had cases like that. So our argument is that given that there are issues with the common law and statutory law as it stands, if you look into customary law, you may find out that the answers are there for the meantime, maybe until the legislature decides to intervene. But the example that Ms. Mbolambi gave was that what was cryopreserved were the germans of the parties separately at the date of the death of the father. And as I indicated, that child would not be eligible to inherit. I hope I've answered the question correctly. Yes.
Okay, I would like to add on the issue of the distinction between ilobola and intlawulo. And yes, I would like just to add on the issue of the distinction between ilobola and intlawulo. And I'm glad that in this conference, we also have traditional leaders, and please correct me if I'm wrong. As far as my knowledge is concerned, when it comes to intlawulo, the father would just pay something to acknowledge that I know this child is mine. You'll correct me if I'm wrong, traditional leaders. Now, when it comes to the issue of ilobola, in terms of our customary law, there's no need for one to, for example, if the relationship between the parents of this particular child has ended. Sometimes, in other instances, the lobola can be paid by the father for what? For only one thing, because he wants to make sure that this child is, since, as much as this child was born out of wedlock, I want this child to be transferred to this particular family so that at the end of the day, as the father, he can also assume my surname. But I'm glad that the traditional leaders are here today. I'm subject to correction. Thank you so much.
All right. So sorry. Lobola would there are scholars who are saying exactly what you're saying, that a lobola can be paid in relation to certain groups, can be paid for the purposes of transferring a child who was born out of wedlock from the mother's home to that of the father. But that's not, I know according to Xhosas, it's referred to what you can do is what is called inkomo yesondlo. Yes, it's inkomo yesondlo. Intlawulo, it's for damages. Yes, but then once the child is grown up, then you can pay inkomo yesondlo, then transfer the child to the family.
Gets to tell us what lobola is. We stand to correct those things in the platform.
messed up. Let me remind you, tomorrow as well, tomorrow, we are starting at 9 again. Not at 10. We had to review the program because we started late today, even though it was 9 o'clock. But this is our appeal. Let's start at 9. Be sharp tomorrow. Make sure that even our hotels, if it means wake up at 6:30 to go have breakfast, and let's do, colleagues, so that we are here on time. We don't have this experience of starting late, so that we end up now missing these opportunities of being glamorous. But okay, thank you, colleagues. Let's move to the venue. Okay, let's get into the car.